Third, I would like to mention one item. SIT 40, it was taken up by Honorable Division Bench of Subhasachay Bhattacharya.
The matter is admitted.
Not admitted, they have asked for call for the LCR. The
No, no.
LCR has come up
Under what heading you want it to be
admitted,
listed?
for admission.
How the single bench will admit your case? It is to be by the division bench.
The division bench has passed an order to appear before the single bench with an order call for the LCR and paper book should be made ready. That is paper book has
And you will let it appear as to be mentioned.
to mention.
Application in connection with second appeal, Lordship.
Yes.
Deeply obliged.
Similar, application in connection with second appeal has been admitted, Milord.
Yes.
Application in connection with second appeal.
The restoration application.
Restoration application of second appeal.
The FMAT IR claim application from railway time.
Yes.
My Lord,
Just one at a time, please.
my Lord, one.
Just one at a time. Yes. Hearing? Yes, to be mentioned first. Hearing of claim case. Yes, to be mentioned.
My lord, mentioning for inclusion in the list, my lord.
Under
Inclusion under the heading hearing.
claim case.
No, sir, hearing.
No, no, hearing of what? Second appeal.
Second appeal, yes.
Second appeal, which year?
Application আছে তো
2025. SAT 161 of 2020.
Okay, next month. Yes.
application in connection with second appeal.
Yes.
Lordship, may I be permitted to virtually mention a matter, Lordship, with your Lordship's leave, Lordship?
Regard to NI Act. Yes, give it.
Lordship, may I be permitted to mention two matters, my lord, from urgent determination of my lord justice.
The matter is appearing in the list.
Yes, my lord, appearing in the
Is it with regard to NI Act?
Yes, my lord, expeditious disposal.
Your lordship include
The
for the application in MSCC case.
Application?
MSCC case.
Yes.
Lordship, mention.
Yes.
I'm praying for inclusion in the list.
No, no. Justice Sharma's determination. Is it appearing in the list?
Your lordship, may I be permitted to mention
Just a minute. Yes.
for the from the determination of honorable justice?
Yes.
It is appearing in the list.
Yes. Has the other side appeared in the matter?
No, it's admission.
Okay. Yes.
Your Lordship, I'm mentioning for application in connection with second appeal. One
Application.
second
Yes.
appeal and one SMAT.
Yes.
Motion matter.
Motion matter of Justice Sharma.
Yes.
Is it with regard to NI Act?
No matter.
No, no. Then this court does not have the determination mentioned before the other bench.
Lordship, may I be permitted to mention an application in connection with a second appeal, your lordship?
Yes.
May I have my lord's kind leave to mention stay applications, claim case for listing, my lord, stay applications,
The application. Yes.
insurance appeals.
Lordship, may be permitted.
Lordship, may I be permitted to mention revisional applications from Justice Sharma, Lordship?
Yes.
Application in connection with second appeal for inclusion.
Yes. Give it.
This is Lordship on hearing matter in respect of claim case, Lordship.
Ready for?
Respect of claim case, Lordship. But Lordship,
Okay. To be mentioned.
Lordship, your Lordship directed this matter to appear on this day, Lordship. But Lordship,
Okay. Let it appear as to be mentioned.
But this is for non-prosecution.
Yes. Give this.
Lordship, I'd like to mention two revisional applications from urgent determination of Justice Sharma, matter pertaining to crime against women, Lordship. 125 proceeding and crime against women, two revisional applications.
Not the determination. I am only conferred with the determination of NI Act. You mentioned
But
before.
Lordship, Justice Sharma is having determination of crime against women also, Lordship.
This court is assigned with the determination of only NI Act, not any other matters. There is another bench which has the determination. Please mention.
Grateful, Lordship. Bow down, grateful.
Yes. Give the slip.
Number one.
My lord, ounce of the applicant I lead by Mr. Udar Shankar Chattopadhyay, my lord. There is-
Yes. You see, the matter is ready for hearing.
Yes, I have.
Very well. I shall take it up in the month of January. But as because there will be a Lok Adalat and there is a instruction from Nalsa to make endeavor to settle the matter, I am sending the matter to Lok Adalat. If it is settled, well and good. Otherwise, the matter will appear in the month of January. Yes. Record an order.
My lord, here is the paper book.
Yes. Yes. Learned advocates for the parties are present. The paper book filed by the appellant be kept with the record. As this matter is relates to motor accident claims and there is a chance of settlement, the matter is referred to the Lok Adalat, National Lok Adalat. Let this matter appear on 5/1/2026 for report of the Lok Adalat.
Grateful, my lord, grateful.
Item number 2.
Yes.
Appear on behalf of the appellant, my lord, the second appeal is of 2015. My
And
lord,
although it has been listed, my lord, but it appears, my lord, it's of 2015, my lord. The SAT number, my lord.
Second appeal, it was filed in 2015.
2015. My lord will go through the admission, order of admission, my lord. It is of December 18, 2015.
Okay, then let it be placed before the bench having determination. Yes. Learned advocates for the parties are present. As this appeal was instituted in the year 2015, being, yes, what was the SAT number? Being SAT number
206 of 2015.
being 206 of
2015.
2015, the matter stands released from the list. The matter may be placed before the bench having determination.
Sri Milord, I beg to appear on behalf of the respondent. Milord, we have filed two applications, CAN 7 and 8. Other applications are disposed of,
No,
paper
it's
book
not
ready.
appearing in the list, your application.
Seven.
CAN
Yes,
7
yes,
and CAN 8, yes, these are your application.
Now, Milord, paper book is ready, appeal is otherwise ready for hearing. Let the application and the appeal be heard, Milord, together.
What is this application for? CAN 7?
Application for, Milord, occupational charge. 7 is for occupational charge. It is, Milord, coming, Milord, arising out of 97 eviction of tenant under 97 Act and occupational charge. And second is, Milord, 2G. The original tenant, Milord, expired. Thereafter 5 years, Milord, lapsed. The appellant is not entitled to reside there, Milord. That is why
So
2G.
you want both this application to be heard along with the appeal.
Yes.
So this is a yes, record and order.
My lord, kindly grant me leave to give file objection in the meantime.
No,
The applications.
I'm hearing out the appeal. I'm fixing a date for hearing of the appeal.
My lord,
If you
No,
see, if the appeal is disposed of, the application will become infructuous.
infructuous,
Okay.
my lord.
But if you want the application to be heard out first, then that
Milord,
affidavit
so
is
far as,
necessary.
Milord, the application is concerned, Milord, that has been served long back. Twice it has been served. They did not. If I'm not wrong,
Learned advocates
there was a
the
direction to file opposition.
parties are present. As this appeal is ready for hearing, let this appeal appear for hearing on 3/12/2025.
312, Milord, today's.
Yes,
Oh, 312. Okay.
the appeal as well as application CAN 7 of 2025 and CAN 8 of 2025 will be heard analogously with the appeal. The respondent is granted liberty to file opposition of CAN 7 of 2025 and CAN 8 of 2025 upon service of copy upon the appellant.
Milord, instead of responding, it will be appellant.
Appellant.
We are responding.
They're the respondents.
You are respondent.
Yes, Milord.
Okay.
Your lordship kindly.
No, whose application is this?
Respondent's application.
Respondents application.
The appellant is granted liberty to file affidavit in opposition to CAN 7 of 2025 and CAN 8 of 2025 upon service of copy to the respondent.
Lordship. Your lordship kindly fix the time.
I'm keeping it at 3 p.m. Okay. At 3, আচ্ছা 3টের সময় 3 তারিখে দেখুন তো কোনো ম্যাটার ফিক্সড আছে কোনো টাইমিং
3 তারিখে মনে হয় সেকেন্ড হাফই তো 3 নেই
Okay, 3/12/2020. The matter be listed on 3/12/2025 at 3 p.m.
Grateful, my lord.
দিয়ে দেন
ও 3 তারিখ আছে কটার সময় আছে 3টের সময় আছে আচ্ছা তাহলে 2 p.m. করে দিন ওটা
Grateful, my lord.
It will hardly take, Milord, half an hour time.
Okay.
My lord.
Grateful.
Item number 4, my lord.
Or I am appearing on behalf of the appellant insurance company, my lord. The paper books are ready.
So it will be hard in the month of January. In the meantime, let it go to the Lok Adalat.
It cannot, my lord, it is on law point, so this,
Take your chance. If it is not settled, I will hear out the matter.
my lord.
Yes, record an order. Learned advocates for the parties are present. The matter is ready for
ready,
hearing.
ready আছে।
However, as this claim case has,
হ্যাঁ, file আছে।
however,
রেখে দিয়েছিলাম।
there is a chance of settlement in this claim case. Let this matter appear before the National Lok Adalat. Fixed
আচ্ছা,
5/1/2026 for report of the Lok Adalat. If
My-
it is settled well and good, otherwise I'll hear out the matter on 5th of January.
my lord. Grateful, my lord. এই যে,
In this matter, I'm appearing to the respondent. I'm appearing for short pass over.
My lord,
Roy is
what-
appearing.
my lord, I think what prayer I will advance before this honorable.
You are
court.
for the appellant.
No, I am for the, my lord, applicant. My lord, what has?
No, what is, whose application is this? Can one?
Mine.
Can one
Section
for?
5, mine. Section 5.
Okay, let it be passed over or not today, whatever it
No,
is.
my lord, rather I would pray for release
Okay,
of.
let this application appear.
My lord,
Have you served a copy of this application?
everything was served. My lord, kindly peruse that.
Mr. Roy is appearing in this matter. Appearing for short
Let
pass
me
over.
pass. Let me.
Okay, I'm passing it over. Let him come and submit.
Because I will pray for release of the matter.
Yes.
I will pray before your.
Okay, let it be passed in the presence of both sides.
My lord, I am for the appellant insurance company. It's a motor accident claim, my lord.
Oh, matter is ready for hearing.
Lordship.
Yes, record and order. Learned advocates for the parties are present. It is submitted by the learned advocate that the matter is ready for hearing and the paper books have been filed. However, the matter is referred to the National Lok Adalat for the purpose of settlement, which is to be held in the month of December. Let this matter appear on 5/1/2026
Lordship,
for
I
report
kindly
of the
fix it up
Lok Adalat.
second week of January, my lord. I have personally.
Okay, let this matter appear on 13/1/2026
Yes,
for report of the Lok Adalat and further orders.
I'm grateful,
If it
my
is settled well and good, others I'll hear out the
Lordship.
matter.
I'm grateful, my lord.
7, I'm appearing on behalf of the appellant insurance company, my lord. This is only on the point of interest. Today itself, my lord can dispose it of. May we come back at 2 o'clock?
Yes, is on the point of
Only interest. Interest. 9% was awarded by tribunal. I've paid for 6% interest. May we come back at 2 o'clock?
yes.
My lord. Grateful, my lord. Nine, my lord. I'm appearing on behalf of the respondent insurance company. On the last occasion, my lord had granted me leave to both of us to file the written notes.
Okay, the matter is already heard out.
Yes, but I need some more time. My lord will only make it not today. I'll come back.
Not today.
Not today. Grateful, my lord.
Your lordship, today may I submit?
My lord, then,
File it tomorrow, okay? I've just adjourning
Okay,
tomorrow.
okay, grateful.
Grateful, my lord.
For the statement. Well, I have mentioned it because last occasion your lordship passed an order in vacation bench. The lordship written in order it is written that some fake currency has been recovered from this petitioner. But this is not a case of fake currency. Only the currency recovered. I have the case diary. There is Caesar list. It shows that only currency has been recovered. This is a case of 302. They have killed someone and looted someone.
Order the parapix. On that ground, prayer for bail, petition number 134 rejected.
Anyway, you renew your prayer. Yes, what was the order passed?
I have kindly see paragraph 3.
Order passed, your lordship passed an order that some fake currency has been recovered. This is not a case of fake currency.
On that
Some
ground,
currency has been recovered.
on that ground, prayer was rejected.
No, I recorded your submission.
Yes, ma'am.
My lord,
I just recorded your submission.
that was not my submission. It is my humble prayer.
No, recorded your submission.
There is no fake currency. So we didn't argue on the fake currency.
No, question is, well, I have recorded your submission. So at this stage, how can I rectify? Whatever was your submissions, I recorded that.
That was not my submission with humble. My lord, kindly take.
Because you argued the matter on that day.
On that day, I was with my senior.
No. Who argued the matter?
My senior argued matter. But
so how is
I am
that?
for the state, my lord. I am for the state. Because I have the case diary, my lordship kindly finds that some currency, a huge currency has been recovered, my lord.
No, what is there?
My lord.
Huge currency was recovered.
But this is a case.
So that word fake has to be deleted.
Yes, only.
That's fake.
Yes,
My lord, on that ground, prayer for bail was rejected.
My lordship perused the Caesar list also, my lord.
Yes, my lord. On that ground.
No. Question is that instead of fake currency, it should be
Only
currency. That word fake was not used.
Fake wasn't. But that is the only.
Yes, record an order.
My lord, on that, my lord, kindly.
On that ground, what should I do? And now, there is no other scope. I have to rectify this one.
Yes,
Why?
Then, my lord, same footing, petition number 2 and others, my lord.
So did they come for recalling that order?
My lord.
So, yes, record an order. Learned advocates for the parties are present. Learned advocate appearing for the state submits that in paragraph number 6 of the order dated 9/10/2025, by inadvertence it is recorded as fake currency, but it should be just number of currency notes. Thus, the word fake mentioned in paragraph number 6 be deleted and rectified as number of currency notes.
My lord, then liberty maybe.
Yes.
Liberty, my lord.
You see, liberty, unless there is an application, there is no scope of granting liberty. You always have that liberty.
They submit fake currency, my lord.
Anyway, that word fake is recorded by mistake, just currency.
Both
my lord, two things. First of all, what he is trying to change is a substantial part of the order. Your lordship rejected because it was fake currency.
Well, after perusing.
Hey,
sorry.
No. Thank you. Your lordship rejected because it was fake currency. Currency in original form is recovered from the other co-accused. FICN, they said.
No,
now,
sorry.
Sir, you finish it, then I'll do it. Finish, please.
No.
Thank you. They said, your lordship sees the CD. The other accused, Asgar, who has been granted bail, from him currency is also recovered. Now, for this person, they say, no, this is FICN. Your lordship recorded that, rejected because FICN. But that was a wrong submission.
The question is,
if that fake word goes, then I am entitled to bail on parity with Asgar. I think the other person name? Robiul, alias Bappa. He has been granted bail by your lordship because the currency was original. So if the word fake goes, so far as the other accused is concerned, I am entitled to bail. Yeah, they got it rejected on the premise that it was fake, which your lordship acceded to. Now they are coming up, it changes the substantial order. Either your lordship, if your lordship.
No, question is, you are present there. Was this submission made? No. Was that submission made fake?
Yes, and that was rejected.
No. According to the learned advocate for the state, the word fake was not submitted. Okay.
Then, my lord, how?
According to you, this word fake was submitted. Then record an order.
My lord, then one.
Yes, just a minute. Learned advocate for the petitioner accused submits that there was a submission by the learned advocate with regard to fake currency. However, in the facts and circumstances of this case, this court is of the view that there cannot be alteration at this stage.
Obliged.
Kindly record our submission that.
Yes, I've recorded that fake should be deleted. But he is objecting, no, that submission of fake currency was made. So it is not possible to rectify this order.
Obliged.
For the petition. Motion, my lord, first time appearing. My lord, the matter relates to conviction and sentence under the provision of 138 NI Act. My lord, the trial court convicted me for simple imprisonment for 1 year and my lord imposed fine of rupees 2 lakhs. My lord, I filed appeal and the complainant also filed separate appeal, my lord. My lord, my appeal dismissed and in their appeal, my lord, the fine amount has been increased to rupees 14 lakhs.
Fine amount is how much?
14 lakhs.
14 lakhs.
Since my lord, the disputed check was for rupees 7 lakhs. So it makes double by the appellate court. My lord, the legally enforceable debt, my lord, I proved by producing the documents, my lord, in the month of February from my custody, my lord.
No, what is the error of this order passed by the learned appellate court?
My lord, what happened in this matter? My lord, appellate court's judgment starts from, my lord, it is only on legally enforceable debt. My check was stolen from my custody by the complainant. My lord, I made GD to that effect in the month of February. They, my lord, served notice in the month of June after 4 months. My lord, I replied to that effect. My lord, thereafter, my lord, the case filed.
So how much is the fine amount?
14 lakhs.
So how much are you ready and willing to deposit now?
My lord, may I say, my lord? Lord, I have no instruction to that effect. My lord, your lordships kindly consider, my lord, it is proved through evidence, my lord, there is no legally enforceable debt. My lord, they admitted in the evidence, my lord. They cannot say what amount they have first time given and last time given, my lord. In cash, my lord, I have given cash. But it is, my lord, the preliminary condition to convict a person that the complainant should, my lord, prove the legally enforceable debt. Otherwise, my lord, the burden cannot shift upon the accused, my lord. And a series of cases by the apex court, my lord, told in the same line, my lord.
So it is in the admission stage.
Yes, my lord. My lord, my only prayer, my lord, your lordships kindly direct me to serve copy upon the other side, my lord. And my record may be called for, since my lord matter may, relates to conviction and sentence. And my lord, the fine amount and my lord, fresh bail, or my lord, the bail which was I am enjoying, my lord, till date, that may be continued, my lord, till the next date of hearing or till the disposal of the case, my lord. This is the system of this court, my lord. In the preliminary stage, only 1 year, my lord. If it is not heard, my lord, I would be taken in custody, my lord.
Yes, record and order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. This revisional application is directed against or judgment and order dated 11th day of September 2025, passed by learned additional district and sessions judge, First Court, Paschim Mednipur, in criminal appeal 4 of 2020.
And another appeal, my lord.
Learned appellate court, by the sage judgment and order, was pleased to dismiss the appeal filed by the petitioner and confirm the sentence awarded, confirm the order and sentence awarded by the learned judicial magistrate, 5th Court, Paschim Mednipur, in CR case number 629 of 2010 and CR case number 626 of 2010. Stop. Learned advocate for the petitioner submits that the learned court, without coming to findings that there was an enforceable date, and when the complainant failed to prove that there was an enforceable date, has awarded the sentence of punishment by the learned trial court and affirmed by the learned appellate court. Upon perusing the order and upon hearing the learned advocates, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 3 days. An affidavit of service be filed. Let this matter appear on 22/12/2025. Pending hearing of this application, there shall be a stay of the judgment and order passed by learned judicial magistrate, 5th Court, Paschim Medinipur, in CR case number 629 of 2010 and CR case number 626 of 2010 for a period of 5 weeks from date. The matter may be.
My lord,
Let this matter appear before the regular bench.
my lord, one thing, my lord, kindly, since my lord, your lordship state that order, my lord, your lordship kindly grant me bail, my lord, or my lord,
It is clarified that the earlier bail granted to the petitioner shall continue till the next date of hearing before this court.
But 5 weeks means, my lord, last week of December, my lord, or before vacation, my lord, kindly.
Anyway, the matter will appear on 22nd. You get it extended on that date.
22nd.
Granted, the bail which the petitioner was enjoying is extended till 22/12/2025.
20. দিচ্ছি আরেকটা আছে next matter between the same parties, same matter, only the check amount is different, same order may be passed. Here, my lord, the lower court case number 629, which is already your lordship referred in the earlier order. Previous matter, my lord, the lower court case number is 626 of 2000.
I have recorded both. Okay, then same order.
Same order. Grateful. My record may be called for, my lord. This.
Okay, if the court thinks regular bench thinks record is necessary, the records will be called for.
13, my lord. 13, my lord, I am for the petitioner. My lord, I paying for only correction, my lord. My lord, Mr. Bidhan Bishwas was appeared for the petitioner, my lord. But in this order, my lord,
His name is
not there, my lord. Instead of his name, my lord, I have correction this.
appearing for the respondent, my lord. My lord, the respondent name is there for the petitioner, my lord.
So all these parties appeared for the petitioners.
No, my
for
lord.
the respondents.
For the respondent.
Mohammad Sarwar Jahan.
My lord, for the respondent, my lord.
For the respondents.
And my lord, Bidhan Bishwas was appeared on behalf of the petitioner.
Yes, record and order. Learned advocates for the parties are present. This matter is put up for necessary rectification. In the order dated 3/10/2025, the name of the learned advocate for the petitioner, Mr. Bidhan Bishwas, which was not recorded, be recorded. Stop. The name of the learned advocates, Mr. Mohammad Sarwar Jahan, MS Mousumi Mitro, and MS Tapusti Sarkar, be recorded as learned advocates for the respondents. Other contents of the order dated 3/10/2025 remain unaltered.
15.
Lord, this is my appeal. I have a application, my lord, Can 1 of 2025. Well, the last order, there was a direction to file a supplementary affidavit because some of the annexures were illegible, but I am filing it now. I have served my other side a copy, my lord. It is only for a correction of the surname of the appellant number 2, my lord.
Correction.
Spelling. My lord will come kindly to the page number 4 of the application. My lord, the main application, not the supplementary one. My lord will see there are two appellants. In the appeal, Gitanjali Malik Khatwa and appellant number 2 is
number
Jhunu.
4.
Malad, in my appeal, there are two appellants. Appellant number 1 is Gitanjali Malik Khatwa. And appellant 2 is Jhunu Khatwa. My lord will see the spelling of Khatwa, Khatua.
Paragraph 4.
My lord, paragraph 4. Page 4, paragraph 4.
Yes.
The spelling is Khatua. But my lord, in my Aadhaar card, the spelling is Khatwa.
Yes. So you want the rectification of name, that the
Yes,
name
as per
of
the Aadhaar
appellant-
card, which would be my lord Khatua.
So in the trial court, it was Khatwa.
TWA.
So award was passed.
Yes, my lord, kindly see.
And in that, no, against that you have come.
Yes.
Yes. What documents did you furnish with regard to that?
Yes. My lord, kindly come to page 3, annexure A in the supplementary affidavit.
Yes.
Kindly see, my lord, in the Aadhaar card, the spelling of Khatwa is Khatua. I am only praying, my lord, in the cost title, let it be changed to Khatua.
Yes, record and order. Learned advocates for the parties are present. This application is taken up for consideration. The appellants in the said application has prayed for rectification of the spelling of the name.
My lord, in my memo of appeal, the spelling is correct. There is no mistake. But my lord will kindly see my prayer at page 5. The SR has reported that it should be Khatwa. At page 5, my lord will read my report. Read the prayer, my lord. There's a report that the spelling is wrong. That report should be ignored.
So as per the memo of appeal,
It is correct. It is correct. It is as per the Aadhaar card. There is no problem in that, my lord. But still,
this appeal is preferred with the right spelling.
Yes.
Okay. But what is the difference?
There's no difference, my lord. Kindly see that there's an order dated 26th February 2025. There's an office report dated 26th February 2025.
Stamp reporters. Yes, the surname of the appellant number 2 of the memo differs from petitioner number 2.
Yes, that is wrong, my lord. That
of the impugned order. No, that means in the award,
yes,
it was Khatwa.
My lord, kindly.
No, in the award.
Yes,
Petition number
yes,
2 means of
yes,
the award.
Yes.
In
In
the
the award, it was KHA TWA.
Very well. Now you want to seek a rectification. You are
Yes,
seeking
it
a
should be
rectification.
KHA TUA as we have given the Aadhaar card, and that office report
Yes,
needs to
learned
be
advocates for the
ignored.
parties are present. This application is for rectification of the name of the appellant number 2 as Bhunu Hatua, KHATUA,
Yes.
instead of KHATWA.
In accordance with its Aadhaar card, my lord.
Learned advocates has also relied upon the Aadhaar card where the name of the appellant number 2 is Jhunu, KHATUA. Stop. As it appears from the award passed by the learned trial court, the name of the appellant is appearing as Jhunu, KHATWA. Stop. However, as this rectification is sought, the name of the appellant number 2 be treated as Jhunu, KHATUA, instead of KHATWA.
Deeply obliged, my lord. My lord, let the appeal
the mistakes be regularized.
And let the appeal be admitted, my lord. I can also file the paper book today. It is ready. I have served him a copy, my
The
lord.
appeal is thus admitted. The paper books filed be kept with the record.
Later date be fixed for hearing,
Yes,
my lord.
I'll fix the date, but as because the Lok Adalat is just within 2 weeks, I'm sending it to Lok Adalat. Thereafter, I'm keeping it in the month of January. Yes, let this matter be placed before the Lok Adalat, National Lok Adalat, to be held in the month of December, and let this matter appear on 6/1/2026 for report of the Lok Adalat.
Deeply obliged, my lord.
Can one stands disposed.
Lordship, I'm there for the appellant. I'm filing the affidavit of service. In Can 1, there is a delay of 116 days.
So have you served copy of this application upon the respondents?
Yes, sir. Yes, Your
Yes,
Lordship.
let me see. Can 1. Item কত নম্বর আইটেম টাকা হলো Can 1 Can 2 টা কি আছে stay
Your Lordship, in Can 2, there's a stay for which I have already deposited a statutory deposit of rupees 25,000.
আচ্ছা এফিডেভিট অফ সার্ভিসটা দিন তো
Affidavit of service and this statutory deposit.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondent in spite of service. The affidavit of service filed be kept with the record. The application Can 1 of 2025 is taken up for consideration. The appellant in this application has prayed for condonation of delay of 116 days. Upon perusing the petition and upon hearing the learned advocate, it appears that the appellant has shown sufficient grounds for condonation of delay. Thus, delay in filing this application be condoned. Can 1 of 2025 is disposed. The application Can 2 of 2025, which is for stay of the order passed by the learned trial court, is taken up for consideration. Can 2 টা দিন একটু As the appellant, insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 27th January 2025, passed by the learned additional district judge, first track third court, Barhampur, Murshidabad, in MSC case number 525 of 2017 for a period of 5 weeks. Stop. In the event, the appellant insurance company shall take steps to deposit the entire awarded sum along with interest within this period of 5 weeks, excluding the statutory amount. Stop. In the event the awarded sum is deposited within the period of 5 weeks, the interim order of stay shall continue till disposal of this application. Yes, liberty, parties are at liberty to mention. Can two pending thaklo one ta disposed.
Seventeen,
Your Lordship, I beg to appear for the appellant.
Yes.
This is an appeal against the order of the learned tribunal dated 29.
Your application can 1 and can 2.
Yes, Your Lordship. Can 1 is condonation of delay and can 2 is for appropriate orders.
So can 1 have you served copy of this application about
Kindly pass directions, Your
Yes.
Lordship. Kindly pass directions, Your Lordship, to serve the order.
Yes, record an order. Learned advocate for the appellant is present. Let copy of the application for condonation of delay can 1 of 2025 be served upon the respondents within how many days we can serve?
A week.
Within 1 week?
1 week.
And affidavit of service be filed. Let this matter appear on 4/12/2025. Under the same heading. No, data served, copy to serve. It agitated, it can want to disposed.
okay. Eighteen.
18, my lord, I am appearing on behalf of the appellant insurance company.
I am appearing with the respondent claimants, my lord. 1 and 2. My lord, copy of
Coming up for the first time, my lord, the statutory deposit I have already made. This is the copy of the challan, my lord.
copy of stay application has been served upon me, my lord. I have been instructed. I have received Bhokaladnama today, my lord.
Yes, record an order. Learned advocates for the parties are present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 26th August 2025, passed by learned additional district judge, first track, 4th court, Alipur, South 24 Parganas, in MSC case number 1122 of 2018 for a period of 5 weeks. Stop. The appellants shall take steps to deposit the entire awarded sum along with interest, excluding the statutory deposit, within this period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the stay order shall continue till disposal of this application.
And I shall also serve upon respondent number 3.
Let copy of this application be served upon respondent number 3. As the learned, as respondent number 1 and 2 is already represented, service upon respondent number 1 and 2 be dispensed with.
My lord. And the money is to be invested in a
The Registrar General shall take steps. No, after you deposit.
after I deposit.
Registrar General, High Court, Calcutta is requested to deposit is requested to invest the sum deposited by the appellant in a fixed deposit of a nationalized bank and renew it from time to time.
And returnable, my lord.
Yes.
Returnable.
Liberty to mention.
Liberty to mention.
Grateful, my lord.
Deeply attached.
Your Lordship, I am appearing behalf of petitioner, Your Lordship. I am led by Mr. Sunny Nandi, my lord. He is on his leg before court number 20.
You are for the appellant?
Yes, Lordship.
Whose applications is this? Can 1 and can 2?
Probably, my lord, this can is not maintained before this because this is an order whereby the Honorable Division Bench, while hearing Order 41, directed to remove the defects. In default, the appeal will stand dismissed. Now, my lord, it could not be done within that period of time, so this application is in file. Probably subject to question, my lord. This will
Anyway,
be.
your other side is.
Your Lordship,
Yes, no, I am not
I'm
that.
just making it not today.
Yes, I am grateful to Your Lordship.
5, my lord, your lordship.
Yes.
For Your Lordship, it was.
Yes, which item?
5.
Item 5, Your Lordship.
Oh, for it.
20.
Let's say I am appearing for the appellant, the learned advocate, senior advocate, Shanti Chadra has not come today.
Okay,
So
not
please
today.
take the matter.
Matter item number 5.
Lordship, praying.
You are for?
I am for the respondent.
You are for the appellant?
Yes, Your Lordship.
Okay, not today.
Grateful.
Let 21. Let this appeal is ready for hearing. my lord.
Appeal is?
Ready for hearing. This is the claimant's appeal for enhancement.
I am for the respondent, insurance company.
Yes.
Well, the ground is that the victim was a goldsmith. Income taken was around 10,000 rupees a month. It should be 30,000 rupees a month on the basis of the income tax returns which have been filed and which are on record. And the
So how much is awarded?
Well, the awarded amount is approximately it is 15,05,000 on the basis of the income being taken as 10,000 per month. Kindly comes to page 8, page 50 of the paper book, internal page 8 of the impugned award, my lord.
Yes.
Right. Accordingly, for the purpose of calculating the compensation, I may take the amount of income of the deceased according to the evidence available before the court, which is rupees 10,000 per month. And just before that, my lord will kindly see, viewed thus, IT returns exhibit 9, 9/1 and 9/2, which are mere self-declaration, fail to prove the income of the deceased. So, my lord, I have come up in an appeal for enhancement only on one ground, that the income tax returns being already there on record and the income tax officer being cross-examined, after that, not taking the income tax return should not have been done. The income should have been assessed on the basis of the income as reflected in the income tax returns. This is my only ground, my lord.
Now, my lord, why I'm for the respondent, insurance company.
Okay, so
my lord,
In this case, income tax authority was examined.
Yes, yes.
PW2.
Kindly come to page 16, my lord, of the paper book.
Yes. Yes. Which page?
Page 16 of the paper book, my lord, PW2.
Yes.
My lord, it reads, I am a summoned witness. I have been authorized by Income Tax Officer, Ward number 39-2, Midnapur, namely Bhuvan Baske, to depose on his behalf. That this is the authorization letter wherein said income tax officer had attested my signature. Authorization letter is marked as Exhibit 8. These are the 3 income tax returns submitted by Prosenjit Jana for the assessment year 14-15, 13-14 and 12-13 against PAN number such and such marked Exhibit 9 series. It appears that in the assessment year 2014-15, which is relevant for this particular case, gross total income of the said Prosenjit Jana was rupees 3,18,470.
Okay. How much was the income tax deducted?
My lord, it is at page, the returns, it starts from page 36, my lord. For assessment year 14-15, it is at page 4040. 3,18,470 is the gross total income and no tax was deducted, nil. TDS was nil.
On 3,18,000, no tax was
No
deducted.
tax was deducted, nil. And after that, my lord, at page 16, the cross-examination. The return submitted by the assessee is made on the basis of his own declaration. After assessment, we used to create process file. In case of nil income tax return, process file is not required to be created. Not a fact that the income of the assessee as shown in the Exhibit 9 series are baseless. This is, my lord, the deposition of the income tax officer.
Yes.
3 years of income tax return is on record. Now, my lord, the tribunal ought to have taken the income tax return of assessment year 14-15 into account. Because once income tax returns are on record, there is no scope for any guesswork.
So how many income tax returns were?
3 years. 3 years, my lord.
So 3 years were there.
Yes. 12-13, 13-14, 14-15.
So how much average it comes?
My lord, as per the Honorable Supreme Court's direction, the average can't be taken into account. The last income tax return has to be taken into account.
Yes. Where is the decision? Please show.
Yes.
Citation to the
2021 TSC 328 SC. Malad kindly comes to, Malad kindly first takes paragraph 6. Just the fact, Malad. In appeal, the High Court concluded that on an analysis of the income tax return filed by the deceased for the financial year 95-96 to 2000-2001, the income declared for the financial year 97-98 was the highest and must be taken as the annual income of the deceased. Hence, 2,09,211 was determined to be the annual income of the deceased. 40,000 per annum was added towards future prospect. The total income was thus arrived at 2,50,000 per annum. No deduction was made towards personal expenses. Applying a multiplier of 13, loss of dependency was calculated to be 32,50,000. To this, funeral expenses, loss of consortium and loss of love and affection were added in amount of 1,05,000. A total compensation of 33,55,000 was awarded. Now, my lord, kindly comes to Next page, paragraph 9. The rival submissions fall for our consideration. The tribunal proceeded to determine the agricultural income arising from 36.76 acres of land on the basis of two judgments of the High Court. The tribunal arrived at two different figures by applying the decisions and proceeded to determine the agricultural income on an average of the two amounts. The tribunal superimposed a possible value of income from agricultural land despite a clear indication in the income tax return of the income from agricultural land. The method adopted by the tribunal is not sustainable in law. On the other hand, the High Court has proceeded on the basis of the income reflected in the income tax return for the assessment year 97-98. The relevant portion reads income from house property such and such, business profits such and such, agricultural such and. The tax return indicates an annual income of 2,11,131 in the relevant assessment year. Mr. Joynath Mutraj, learned senior counsel, appearing on behalf of the appellant, contended that other documents were marked which reflected the income of the deceased. We are in agreement with the High Court that the determination must proceed on the basis of the income tax return where available. The income tax return is a statutory document on which reliance may be placed to determine the annual income of the deceased to the benefit of the appellants. The assessment year 97-98 and not 99-2000 or 2000-2001, which reflect a reduction in the annual income of the deceased. So, well, I am not even going after the highest. I am only saying the last income tax return relevant for this year, 2014-15, 3 lakh rupees odd has to be taken. In any case, my lord, in this particular case that we are in, the 3 years return, if we look at it, the figures are, I'll just indicate to your lordship. It starts from page 36 of the paper book. First year, 1,79,073 rupees. After that, 2,99,860 rupees. And the last year is 3,18,470 rupees.
Yes. That is
so
36.
Yes, 36 onwards. From page 36, assessment year is 12-13, which is financial year 11-12. It is 1,79,073 rupees. Next year is 2,99,860 rupees, which is at page 38. And the next to next year at page 40 is 3,18,470. So, my lord, I am saying, humbly saying, my lord, this amount should be taken into consideration.
Page 40.
40, my lord.
So, income tax is not payable.
No, nil. And my lord, there's absolutely no confusion because these documents are not subsequently manufactured. These have been filed before the accident. So there's no question of inflation or manipulation with regard to the income tax returns. These are documents which are filed before the accident, out of the control of the assessee, the victim. The income tax authority has come, and in the witness box, he has been cross-examined by the insurance company. So there is absolutely no basis, my lord, not to take this income tax return which has been filed. Whereas specifically they have cross-examined the witness. Nothing remains, my lord.
My lord, kindly come to 48, page number 48 of the judgment. Judgment page number 6, running page number 48.
48 of paper book.
Paper. Issue 527. Here, my lord, the learned tribunal has clearly explained that why the learned tribunal considered rupees 10,000 and did not consider.
Yes, which page? Page 48.
Page 48, issue number 527.
Yes.
May we permitted to read, Mal?
Yes, yes, yes.
Now
What were those issues? 5 to 7?
5 to 7 issues are regarding income, my lord. Page number 45 5. Page
Yes.
number 35. Whether the offending vehicle was involved in the accident in question, whether the death of Proceedings journal was caused in the accident on such and such date, whether the offending vehicle was under insurance coverage on the date of accident, whether the claimants are entitled to get any compensation from the insurance.
Yes. Now 5 to 7.
Here, my lord, in page number 48. Now the question arises as to whether the claimants are entitled to get any compensation, and if so, to what extent. It is the case of the claimant that the deceased was self-employed as goldsmith. Aside from mere denial of this fact, the insurance company has not come up with any sort of evidence to negate this fact. In my view, the deceased was a goldsmith, and this fact is therefore proved in this case. According to the claimants, the deceased used to earn 30,000 per annum per mensem as goldsmith. To substantiate the income of the deceased, the claimants have cited the IT inspector on dock of SPW2, who in turn has proved the IT return filed by the deceased for the assessment year 2014-15, 13-14, 12-13 as exhibit 9, 9/1 and 9/2. According to the learned counsel of the claimants, the income of the deceased for the assessment year 2014-15 was 3,18,470, and this fact is accordingly proved in this case. I have carefully perused. Next page, madam. I have carefully perused the IT return of exhibit number 9, 9/1, 9/2. It appears therefrom that the gross income of the deceased was 1,79,073 for assessment year 12-13, 2,99,860 for assessment year 13-14, and lastly 3,18,470 for assessment year 2014-15. The PW1 has deposed on doc that she will file the bank account statement of the deceased, but she did not care to file it. When it is asserted that the deceased was self-employed, the claimant ought to have tendered some sort of documents to show the fact that the deceased was a self-employed and a goldsmith, as claimed. Unfortunately, no scrap of paper or documents showing the self-employment of the deceased as goldsmith has been cited in this case. In the juncture, it is found that the PW2 has uttered on doc that the deceased had LIC policy, and this will be PW1 LIC policy, and she would file the relevant documents. However, no such document has been cited in this case. To be precise, beside those IT returns, exhibit 9, 9/1, 9/2, there is no other scrap of papers or documents available before the court to hold that the deceased was having yearly income as shown in those IT returns from his self-employment. It is not the case that the claimants do possess no other such documents like bank account papers and LIC papers of the deceased, which on being produced could have thrown some credibility on those IT returns, as because those IT returns are nothing but mere self-declarations by the deceased. To put it otherwise, those IT returns stands verification and scrutiny cannot be blindly treated as a sacrosanct regards to the income of the deceased, when it is evident that there are some documents relating to the financial transactions by the deceased, and those are available. Non-production of those that tool without offering any explanation causes serious dent to the case of the claimants. That the deceased, a boy of 27 years, had such yearly income as shown in this IT return. Exhibit 9, 9/1, 9/2. The claimants have not shown their courage to table the bank account or LIC policy premium of the deceased to buttress the fact that the deceased had self-employment as goldsmith and had such income as shown in IT returns. Viewed such, the IT returns of exhibit 9, 9/1, 9/2, which are merely self-declaration, fails to prove the income of the deceased. However, earning rupees 10,000 per mensem as goldsmith at the relevant time is not wholly indigestible. It is therefore found that the deceased used to earn rupees 10,000 per mensem as goldsmith at the relevant point of time. So, my lord, here, these documents, if your lordship kindly go through these documents, my lord, which they have exhibited, that is the IT returns in page number 40. I think.
Yes. So how much you see monthly? That means 1,20,000 is considered to be the yearly income.
Yes, it should be 3 lakhs. And my lord, whatever Mr. Bhattacharya is
Anyway, let him complete.
Yes.
In the IT return, my lord,
Yes, which
Well,
page?
The learned tribunal has rightly, my lord, disbelieved the IT return, my lord. Page
Yes.
number 40, if your lordship kindly come. Total income such. There is no, my lord, breakup. That from in page number 41 also, my lord, opening stock such and such, purchase, salary, printing stationery, no, this only self-declaration, my lord. It does not.
But believed by the income tax authority, but not believed by the court. This is the position.
Yes.
Okay.
Well, an absolutely wrong appreciation of the law by the tribunal as well as Mr.
Anyway,
Bhattacharya. Well,
the
this
court
point is
disbelieves
out.
it. Although the authority has believed, the court has disbelieved it.
Yes, Malad, kindly see this judgment. This is our High Court's coordinate bench judgment. Absolutely same facts and circumstances. Paragraph 10. Mr. Mondol, learned advocate for appellant claimant, in reply submitted that though income tax return is self-declaration, but the same is assessed under section 143 of the Income Tax Act, and as such it should be relied upon. There is no cross-examination on this. He further submitted that the investigator OPW2 in his cross-examination has submitted that he cannot show any document that he went to the house of the deceased and intended to see the documents of income of the deceased, and therefore his evidence that the claimant failed to produce any document of income of the deceased should be taken with a pinch of salt. Having heard the, and now my lord, paragraph 11.1, absolutely same facts. With regard to determination of income of the deceased victim, it is found that the learned tribunal considered notional income of rupees 3,000 per month as the income of the deceased victim and refused to accept the income disclosed in the income tax return for the assessment year such and such on the ground of absence of supporting documents of business and submission of only one income tax return. The claimant, in order to establish the income of the deceased victim, examined one Soumoshanto Ghonta, Inspector, Income Tax Department as PW3, who produced the true copy of the income tax return for the assessment year such and such, marked as Exhibit 9, filed on such and such prior to the death of the victim. As per the income tax return of the assessment year such and such, the gross annual income of the deceased victim was such and such, and tax paid was 2310, and the description of the business is motor parts and order supply. Such income of the deceased victim appearing in the said income tax return has been challenged by the insurance company on the ground that it has not been duly supported by documentary evidence. Now the question arises whether in the facts and circumstances of the case, the income tax return of the deceased victim for the assessment year 12-13 can form the basis of determination of the income of the deceased victim. OPW2 Bijoy Ketan Mukhopadhyay, in his evidence in chief, stated that he went to the house of the deceased for investigation in connection with the case on behalf of the insurance company, but the claimant did not show him any document in respect of the income of the deceased on the date of accident. However, it is relevant to note that in cross-examination, this witness admitted that at present he had no papers to show that he went to the house of the deceased for investigation and he intended to go through the documents in respect of income of the deceased at the time of accident. During the course of proceeding, neither any document in support of visit nor a single scrap of paper bearing signature of the claimant with date of such visit was filed from the side of insurance company to probabilize such visit. Thus, in the absence of any document of visit, evidence of
Facts are different in
yes,
this case.
Malat, kindly see subsequently the observation. Exhibit A is noted as serial number such and such. Now, my lord, come to the next page. Save and accept income tax return. There are no other documents of income of the deceased victim. My lord, in the middle of page 8,
Save and accept income tax return. There is no other document of income of the deceased victim. It will be profitable to refer to Kalparana's case, where the only available documentary evidence on record of the monthly income of the deceased was the income tax return filed by him with the income tax department, and the Honorable Supreme Court in such circumstances held that High Court was correct to determine the monthly income on the basis of income tax return. Further, the Honorable Supreme Court in Malarizvi's case, the other case that I have cited, my lord, endorsed the finding of the High Court that determination must proceed on the basis of income tax return where available. The income tax return is a statutory document on which reliance may be placed to determine the annual income of the deceased. So, my lord, it does not require any other document to be proved. It is in itself a complete document which has been cross-examined and marked as an exhibit without objection. It does not require substantiation or breakup. If any question had to be put, if any doubt had to be raised with regard to the income reflected in the income tax return, it had to be raised against that particular witness who has stepped into the witness box. The question should have been put that whether the income declared has it been assessed or not? Is it fake or not? Has it been filed after the date of accident? None of those questions has come across. So, my lord, bringing further document, if any further document would have had been brought, that should not have had been considered when an income tax return is there. Well, the Honorable Supreme Court is very clear that once income tax return is there and it has been filed prior to the date of accident and the income tax officer has been cross-examined, there is no further scope. And regarding the LIC document, there is a clear breakup in the income tax return. At page 40, I have claimed deduction under chapter 6A. Why do I need to give that LIC premium, how much I am paying? I have claimed deduction of chapter under 6A. If you doubt, if the insurance company doubts the deduction, they should have put the question to the income tax officer that whether this deduction claimed has been disputed by the income tax authority or not.
The income tax paid has
Yes.
to be deducted. Okay.
Yes.
That is, here there is no income tax.
No income tax, only the deduction.
Now,
They have brought up the issue of
now after
LIC.
After deducting that, it comes to 2,18,470.
No. My lord, 3,18,470 is the gross income.
Yes.
From that, deduction is not under chapter 6A, that should not be deducted. Only tax is to be deducted.
To assess tax, you see.
Yes.
That
there is no tax on 3,18,000 rupees.
Question is, but you see, after deducting, after you avail the deduction, from that 2,18,000, it will be considered whether you are liable to pay tax or not.
Yes.
After you
that
avail
is taxable income.
Yes. After you avail the deduction,
yes,
1 lakh.
Yes.
It will be considered whether you are liable to tax or not. That is 2,18,000.
Yes, on 2,18,000 there is no tax, but my income should be taken as 3,18,000 because this 1 lakh rupees LIC premium and everything that I am paying out of my pocket. The law is, my lord, gross income less tax. If there is no tax, then gross income should be my income.
Okay, this is the benefit you are getting.
Yes, this is the benefit I am getting.
So the benefit, and this is not statutory deduction.
Yes. My humble submission, my lord, as per Exhibit 9, the income should be 3,18,470, which the income tax officer has also confirmed for the assessment year 14-15. Other points, my lord, I am not going into it because everything else is multiplier and deduction and future prospect, all that is correct. Only the income should be from 10 lakhs, it should be 3,18,000.
Submit only one thing. The judgment which has been cited by my learned friend, in that judgment, it shows that there was no other document to substantiate the income except
income tax return.
But in our case, the PW.
The other documents can be manipulated in the business. So many things can be done, but these returns cannot be manipulated. This It is with the authority. Authority is the competent person.
They admitted that they have
So
the
what
documents.
usually a person does not inflate his income. You see, there is always a tendency to pay less tax. So the income which is shown definitely cannot be disbelieved. The person will not show the inflated income to get some reputation.
My lord, they have undertaken to file.
These private businesses, so many things records can be manipulated. But these documents, they are more reliable than these business records.
No, my lord, bank documents, bank.
What else? Bank, so many transactions there. Why they will disclose these bank documents unnecessarily? So many this personal incomes and so many things are there. Why they will disclose unnecessarily?
And this person died in December. He submitted the income tax return in July, much before the
The
Yes.
accident.
submission is that, my lord, in absence of any other document, it can be relied upon.
Is that the law? If that is the law, no. If that is the law, that in absence of other documents it cannot be accepted, the court will follow that. If that is the law,
That can be accepted. Here they are admitting that they are.
all right. Yes. Anything else?
Nothing else, my lord. Only this point.
Yes. Record an order. Learned advocates for the parties are present. Are learned advocates. Hearing is concluded. 6/4/2025 for judgment.
Deeply obliged, my lord. Deeply obliged.
আজকে কোথায়? আজকে না 26 তারিখে এই লিস্টে আছে? হ্যাঁ, তো আমাকে দেখাবেন তো রেকর্ডটা কি আমার কাছে আছে? দেখতে হবে তাহলে। 26 তারিখে পরে একটা ডেট দিয়ে
Number 22.
Madam, appearing for the clemency appellants.
The respondent praying for not today.
Better your lordship kindly fix the matter on Thursday.
So it's better I send it to Lok Adalat
My lord,
for the
already
purpose of
failed.
settlement.
Already failed.
Earlier.
Earlier.
Okay, then not today only. Acha, let this matter appear on
Thursday.
huh? Thursday তে দিয়ে দেবেন।
They did. Is that the Chironjoy Das?
Number 20 and 24.
In this matter, regarding item number 23,
Some mistake, my lord. My lord, the cross objection is cross objection number 136 of 2025. The
Yes.
related matter FMA 809 of 2024. My matter is FMA 809 of 2025. But with Mr. Mondol's appeal, my cross objection has been tagged.
Anyway, then you give the slip, let it appear under the proper heading.
Yes.
My matter has been disposed of.
Whatever it is, you give the slip.
Yes.
Let the yes.
No.
File কোনটা আছে? File
No, you give the slip, the matter which is to be listed.
My lord.
এখানে আসলে কি নাম আছে?
ইয়ারটা কোনটা? ইয়ারটা
ও না, তাহলে এটা আমাদের নয়।
ওটা দেখুন লিস্টে ভুল ছেপে গেছে। এটা হচ্ছে কারেক্ট নাম্বার। ডিপলি অ্যানালাইজ করলেন। এইটা কারেক্ট নাম্বার, লিস্টে ভুল ছাপা হয়েছে। এফএমএ নাম্বার দেখুন 2024 হয়ে গেছে লিস্টে। হ্যাঁ, ওটা 2025 হবে। আমি দুটো নাম্বার লিখে দিয়েছি আপনাকে। লিস্টে ভুল হয়েছে, লিস্টে দেখুন 24 হয়ে গেছে।
Okay, not today.
Number 25 and 26.
Appear on behalf of the appellant insurance company.
Respondent, I prepare the paperwork that I have served upon the appellant.
Yes.
If my lord kindly comes to the paper book, page 42, is the award impugned. May I place it?
Yes.
সব জানেন সিভিল একদম কিছু বলতে হবে সিপিসি লেখা
হ্যাঁ সিপিসি আমার লেখা
ওর লেখা সিপিসি এখন চলছে
আমার থেকে চলছে
ওর লেখা সিপিসি চলছে এখন
Yes.
This is an application under 166, wherein my lord, the claim case was allowed. If my lord sees the application once, and that is at page 1 onward, wherein a claim case was initiated due to some motor accident, and kindly comes to page 35 once of the paper book.
Yes.
This is a post-mortem report.
Yes.
If my lord kindly sees the portion, the stomach and its content.
Yes.
Fifth line, my lord. Paragraph 4.
No, postmortem report you are relying?
Yes.
Yes.
Kindly sees, my lord. 4, my lord. Stomach and its content. Full of.
That is 1, 2, 3.
5, 5th.
Category number?
4, my lord.
Yes, stomach full.
Stomach and its content. Full
Yes.
of urgent material, alcoholic smell.
Yes.
If I kindly marks it, my lord.
Yes.
It's essential. Now, my lord kindly comes to the judgment. I will be placing the petitioner's case is in brief is that on 27 page 42.
Yes.
The first paragraph I am not going, my lord, but the petitioner's case in brief that on 27 December 2020 at about 1:25 AM, the victim Ganesh Das and Subroto Jana was coming from Nimtauri side and proceeding to Nandakumar side through the left side of NH 41 by a motorcycle bearing number so and so. The rider of the vehicle driving the motorcycle was very slow, sincerely and cautiously through extreme left side on the road. The said motorcycle reached so and so. At that time, the offending vehicle, which was coming from Nimto proceeding towards Nandakumar, very excessive speed in zigzag manner, suddenly through a high alarm, rashly overtook the motorcycle and stopped in front of the motorcycle, disturbing the free flow of the motorcycle, and having no other alternative, said motorcycle was bound to dash at the side backside of the offending road as a result of great jerk arrows. Both Ganesh and Subroto was thrown away from the road, and the motorcycle sustained severe injury and died on the spot. PM postmortem report of Ganesh Das was held. This is the postmortem report of my lord Ganesh Das, page 35.
Yes, yes.
So he was in the vehicle, my lord. He was as per
He was driving or he was sitting in the motorbike.
he was sitting in the
Motorbike. Somebody else was driving the motorbike.
Subroto was
Driving.
He was. Both were in.
No. Subroto was driving, but this person was not driving. He was simply sitting.
My lord.
That means after, if a person drinks, the driving is prohibited.
My lord.
So, but this person was sitting. The other person was driving.
Yes, yes.
He was the pillion rider.
Now, my lord, this was the entire issue. Kindly comes to page 44. I am not taking the entire portion, my lord.
এই পেন্সিলটা নিছি ব্যাগটা বললো কিছু উপরে দাঁড়িয়ে হবে না তো সে পুচ্ছে তো পুচ্ছে তুমি বলো না তোমারটা
Yes, what was the case of the claimant? The truck dashed from behind?
Yes. Front.
No, from? So it is a head-on collision.
My lord.
No, Lordship.
No, truck came from the front or no, dashed, you see?
No, Lordship. He's just not.
No. What was the case of the claimants?
What is the case of the claimants, Lordship?
Motorcycle dashed the backside of the offending truck.
No. Lordship, may I say? তাহলে বলো তুমি সঠিকটা বলো
তুমি বলো
No, let him
ঠিক,
complete, let him
তোমার কথা
complete.
শুনে চলবো না
প্লিজ তুমি তাহলে বলো সঠিকটা কোন থেকে বলো
প্লিজ টেক ইউর সিট দেন তোমার কথা তো শুনে আমি চলতে পারি ইন দ্যাট
ড্রাইভিং দ্য মোটরসাইকেল
Let him complete. I am just clarifying. That is the
fact I am submitting. I am not questioning on the fact. He is not properly briefing the fact.
Then probably if I am not properly briefed, let me properly brief. Kindly keeps it on.
Next year, next year,
next year,
next 2 years. So enjoy the stay order. Basically, vacate the stay order immediately.
I have deposited the entire amount.
That's why vacate the interim order. Allow the claimants to withdraw the order amount.
Kindly keeps it on.
No, certainly not.
Next year.
I will make my submission here and now.
This is not the process of arguing a matter.
So you are misleading. It is not the hidden condition, but you are saying
this cannot go on.
So what is the case of the?
Kindly.
I'm asking what is the case of the?
He has made an allegation from the bar that I am not properly.
Not I am making allegation.
Let me properly get brief for my client. Kindly takes it.
Very well, Lordship. Kindly take the interim order here now. They're enjoying the interim order. That's why asking for time. Earlier, 2-3 occasions they have taken time.
So question.
Attend the matter.
First, let me clarify the position. You see, what is the position? What is the case of the claimant? That they have to adduce evidence on their case.
Kindly comes to page 15, my lord.
Page
15.
15.
15.
15. Yes.
Let me place it in own way, my lord. This is the written statement of the insurance company. Kindly seize, my lord. Paragraph 5. Paragraph 5 is my specific statement that as per the postmortem report, both the victim Subroto and Ganesh Das, the stomach and its full content of liquid material with alcoholic smell.
Oh, both of them died?
Yes.
Yes.
Now my Lord's query kindly comes to page 4 of the paper book.
Yes.
That on 27th December 2020 at about 1:25 a.m. night, the victim Ganesh and Subroto were coming from Nimtauri side and proceeding towards Nandakumar to the left side of NH 41 by motorcycle being. The rider of the motorcycle was driving the motorcycle very slowly and sincerely and cautiously to extreme left side. When the motorcycle reached Coimbatore bus stoppage, at that time, offending vehicle which was coming from Nimtauri side and proceeding towards Nandakumar side with a very high speed with a zigzag manner. At that place of occurrence, the said offending vehicle all of a sudden, without raising any alarm, rashly overtake the motorcycle and stopped in front of the motorcycle to disguise the free flow of the motorcycle. After that, no other alternative, motorcycle bound to compare dashed backside of the offending truck. My lord, kindly sees, my lord. Backside of the offending vehicle and the great jack arrows and Ganesh and Subroto were thrown away from the roadside and sustained serious injury and died on the spot due to the accidental injury. Postmortem was heard so and so.
Yes.
Now, this entire postmortem was exhibited. This was the case of the insurance company, the tribunal, my lord, and on which award was granted.
No, the charge sheet was submitted against the vehicle of this lorry.
Not so. Yes.
Truck driver.
But the postmortem report was exhibited, where it is evident.
What is your ground for challenge?
My ground is kindly comes to page 58. Round 3, my lord.
Round
3.
3.
Hello.
Yes. So there was no insurance policy. Oh, the truck was insurance policy of the offending vehicle was there.
Yes.
Who was the owner of this motorcycle, this victim motorcycle, these victims?
My lord. But that was not.
And you obtain document from the registering, that is transport authorities, that this motor vehicle is not covered or by insurance.
No,
That you have obtained.
That was not there.
Or whether these persons who were driving the motorcycle had driving license or not.
No, that was also not there. But we kindly comes to my additional written statement also at page 13.
Page
13. I have taken these please, my lord, but those were not.
30. Yes. Page 3013.
13.
How much was the income as per the?
Kindly comes to page 653, my lord. Kindly comes to page 53, my lord.
Yes.
Third paragraph, it is pertinent to mention here the future prospect deceased was used to earn 15,000 per month. Third line.
Yes. So what evidence was adduced?
No, there is no evidence, my lord.
So this is the claim case with regard to one of the victims.
Yes.
Yes. Which page is the charge sheet?
Charge sheet page 28.
পেন্সিলটা নিয়ে আসিস নি এখানে দাগ দেওয়া আছে অরিজিনাল কপিগুলোতে।
Yes.
The kindly comes to page 51 once.
Yes.
The first
Running page 51.
Yes, yes, of paper book. 51.
Yes.
First paragraph. To prove that the income of the deceased claimant did not adduce any specific evidence. However, PW1 in her evidence stated her husband was an expert body mistri of a machine van of Vishwakarma engineering works by profession, used to 15,000 per month from the said profession. But except these oral evidence, there is no other documentary evidence to substantiate the income of the deceased per month. Hence, my considered view, the income and the profession was not of the deceased is not proved in this case. Now, my kindly comes to the last line of that page only.
Yes.
Unit code here that I am inclined to accept 5,000 per month of the deceased notional income.
Now, suppose in case of low income persons, you see that no fault liability can be attributed also. That theory can also be applied. Suppose this person is a low income. So, assuming there is some fault on the part that by applying that no fault liability, a particular amount can be awarded.
5 lakhs.
5 lakhs. So, what is that quantum with regard to no fault liability?
The 163.
163A. You
That
see,
is-
court has the discretion. If
Yes.
it is a low income person, that it can be converted to 163A also.
That is 5 lakhs.
No, 5 lakh is the maximum amount.
That has been consolidated, that amount.
So,
now.
yes. But income. There must be a category of income who comes under no fault liability. All persons do not come under this no fault liability. You consider that provision 164.
বইটা আমি দেখব it does not come with the book also is হিসাবে ভুল বলে বলে দেবো হচ্ছে কাটা ওখান থেকে
না কাটা বোকান
আচ্ছা এগুলো সঠিক বলো তাহলে কতক্ষণ লাগবে আলোচনা ভুলতে in the meantime, I will
Kindly,
assist us.
164. May I
Yes.
read, my lord? Notwithstanding anything contained in this act or any other law for the time being in force or instrument having force of law, the owner of a motor vehicle or authorized insurer shall be liable to pay in case of death or grievous hurt due to any accident arising out of use of motor vehicle compensation, a sum of rupees 5 lakh rupees in case of death and 2.5 lakh in case of grievous hurt to the legal heirs as the case may be. The consolidated 5 lakhs.
So, that can be in case of no fault.
Yes.
Assuming if this is applied.
Yes.
That means that consolidated amount comes to 5 lakh. And how much awarded? 11 lakh.
11 lakh না তুমি বলো আমি বলবো
11,41,000.
That is irrespective of income. Earlier there was an income up to a poor person, up to a particular. Now it is uniform that
No
simpliciter by way of accident.
5 lakhs.
5 lakhs can be granted. So courts are also empowered to convert it into 163A. Yes, what do you say?
Lordship, the application file under section 166, they are taking the risks to prove that the rash and negligence. In the 116A, the question of rash and negligence not required to be proved.
No.
So this cannot be converted in such way. Once I have proved that the rash and negligence, then I have to come within the zone of 166. There's a simple law, Lordships award that. So there is no ambiguity or there is no, so it can be, but Lordship here, the charge sheet file against the offending vehicle. Privacy, the rash and negligence has been proved. That is, Supreme Court judgment is that once charge sheet filed against the driver of the offending vehicle, that is presumed that the rash and negligence already been proved. So once that is proved, And that proof is not required under section 163A. So it cannot be converted in automatically. And then Lordship kindly come to basically there is the appeal has this is maintainable. Appeal is not maintainable appeal. Because of Lordship, kindly see they have taken a plea in the SMIL, page 35 of PM report, SMIL, but they did not adduce any evidence. Even then, they also filed an application for additional evidence. So, to prove this document, Lordship kindly come to their additional evidence.
No, the postmortem report is exhibited by you.
Exhibited,
It is your document.
This is a document of a government document.
Whatever it is, it is relied by you.
I'm relied by
Clement's document.
Yes, the postmortem document is anti-mortem in nature. As you kindly see that, this is anti-mortem in nature. And one thing is, Lordship, he was as per submission of Mr. Bhattacharya, he was a pillion rider. What is the fact in that? Fact is that the truck overtaking the motorcycle. Suddenly overtake and stop. For the reason they dash behind. So accordingly, the truck is the entire liability for liable for the accident, not the deceased or victim. So for that is the victim has no contribution to the accident, whether it's consuming liquor or not liquor, it's immaterial. Because of truck suddenly stop in front of the motorcycle, the accident took place. Where from we come that? Because and the see that there is no evidence, not a single evidence they have produced before the court of law to prove their case. This is not my case. This was the drunken stage. This is not my case. But you have to prove by you are asking the doctor that the doctor's name also appearing in the charge sheet. Lordship also asks them to what is the charge sheet. Page 28. Lordship kindly see that the name of the doctor is appearing in the charge sheet. The Burdwan Medical College. Lordship kindly come to page 30. Dr. Umesh Das, MO, District Hospital, Tamluk. He also cited in the witness, but they did not make any summon to him to the witness. And Lordship, another is that.
Now you see, there is a provision that you see after drinking, driving is prohibited.
No, Lordship.
But no. But how many hours is that?
No, Lordship. May I?
Is there any time gap as per the rules?
Yes, Lordship. Kindly come to the law. 185. Driving by drunken person or person under the influence done. First of all, Lordship, my humble submission, accident took place on the fault of the driver of the offending vehicle. He has overtaken the motorcycle and stopped, and accident took place. The victim has no contribution to the accident. Just received the grievous injury and died. Whether a drunken stage or not drunken stage is immaterial. But the question is, the drunken stage, if suppose the truck driver was in a drunken stage, then Lordship could have raised the question. The truck driver, that evidence was not there. Someone died. He was drunken. So what is the evidence? Then Lordship kindly see, has in his blood alcohol exceeding 30, there is a statute, 30 milligram per 100 ml blood. This detected a test by the breath analyzer or any other test, including the laboratory test. Where is that? How he consume more than 30 milligram? That evidence is there. Appeal is that, Lordship, kindly, Lordship, appeal is that the evidence adduced by the parties, the learned tribunal did not gone through the evidence and pass the judgment. The learned tribunal did not consider the evidence available on the record, but passed the judgment. But the learned tribunal not at all consider the question of law. Then what is the appeal before your Lordship? What the wrong committed by the learned tribunal? What is the appeal? That you kindly come to that appeal, prima facie. What is the appeal? Appeal is that he has passed 11,41,000. That cannot be a ground. Then let you kindly see the next. The postmortem report being, so why postmortem report is the deceased the alcohol found. Smell found, not alcohol found. Let you kindly see the smell. Let you see the note, page 35. Kindly get page 35. For smell, let you will found the word smell. Nothing. The smell found. What is the section 185? That is the statute. Let you kindly come to the statute 185. Yes. What is the quantity found? Smell found. There is no evidence on the score. They did not adduce any evidence on the score, Lordship. So, Lordship, the driver who was driving the vehicle, here the offending, my case against the offending vehicle. The offending vehicle driver was fit and fine. Fit and fine, Lordship. There is no allegation against the offending vehicle of driver. How the accident took place? The PW2 being eyewitness described the
The
situation.
another ground taken, one is this drunken condition, the other is the vehicle, the victim vehicle
Yes.
was not insured.
There is no evidence. There is no evidence. They have taken there is no evidence. This not evidence is not required. My claim against not the victim vehicle. So why question is raised against victim vehicle? My claim against the offending vehicle, not against the victim vehicle. If the victim vehicle my claim, then I have to prove my policy, whatever
Other
policy
is
required.
the driving license was not
But
there.
I have no claim against the victim vehicle.
No, driving license of the victim was not there.
Required. Not required. Not required, because I am not against him. Suppose if the offending vehicle has no valid driving license, then what will happen? The owner will be liable.
Whether there will be a contributory negligence or not, if there is a no driving license of the victim vehicle.
In essence of driving license, the contributory negligence question, that conception is not the law.
Suppose
Maybe
the victim did not have any driving license.
There is no evidence. There is no question at all put by the insurance company by the learned tribunal. Kindly come to the evidence. Only two evidences, that no evidence in support of insurance company. Where from is get it? And then you kindly come with our High Court judgment. Kindly come to page 23. Is absolutely the appeal is not maintainable. They are taking the plea whether as if that the offending vehicle, the driver of offending vehicle consuming liquor. That is not the case.
Anyway, there was no evidence.
There is no evidence. Then
the insurance company.
More so, Lordship, kindly see paragraph 23 of my just answer. Lordship will get the answer from this our High Court judgment, the division main judgment. Lordship, kindly see. Just see the judgment. Therefore, me to run short there. Paragraph 23. Therefore, the said postman record, because of that is not my case also. Even then, I am placing this judgment. Cannot even suggested that it not the Pasuputi was influence of alcohol. Here, Pasuputi is the Lordship driver of the offending vehicle. So he is the victim. When the said accident took place, Lordship, kindly see the basic Pasuputi in Legacy 2, he has alleged under the influence of drink. He said postmortem report, however, says the Pasuputi died because of his antemortem injury. That is also found in the postmortem report also. While on the subject, it should also be pointed out that none knows sort of medicine were given to Pashupati in the hospital, by what method or methods such medicine were given or administered for reducing his physical pain caused such injuries to save his life. Whether medicine that were given Pashupati containing alcohol, as it nobody's case that alcohol was consumed by the Pashupati either before or after he was admitted to the hospital. Just see the answer is given by the Apex Honorable High Court, our division bench. Even then, that is not the case, my lord. I am repeating the one sentence. It is not my case. It is not my case. The driver is permissible to consume alcohol in view of section 185. That always seen that. What is the appeal? The learned appellant travel beyond the evidence. What is the appeal? Yes. Now, she just kindly come to page. I'm going to more travel to your lordship. Lordship, kindly come to page paragraph 6. There is the Supreme Court judgment. Just paragraph 6. Kindly see. Just kindly come to paragraph. Now, she got it. So for the stand, the accident occurred because of deceased was an intoxicated state it concerned. High Court has rightly noted in absence of any pleading or evidence to substantiate the state, there was no scope to accept him the plea. What is the evidence? They have taken the plea in the written statement. Once you have taken the plea in a written statement, so whatever plea you have taken in your plaint, you have to prove by your evidence. The written statement supposed to be a deemed to that is the plaint of the defendant. So you have to prove the case by producing evidence. To be silent about the issue before the learned tribunal. This learned tribunal is the original court of law. Lordships aware that. So they have enough scope to produce whatever you would like to produce. But it was silent over there. They reserve your right. The appeal is a statutory appeal. Let's kindly mind it that. The appeal is a statutory appeal. The statute given that option to the parties to paper an appeal. When the appeal is statutory appeal, you have to close the question of law. What is the question of law involved in the appeal? Let's kindly find out that question of law in the appeal. Kindly come to the grounds of appeal. It is true. It is true that the grounds, which whatever grounds they have taken, they can orally, he can at the time of hearing, they can take another grounds apart from the grounds they have taken. That is Mr. Bhattacharya also aware of that. But Lordship, kindly see what is the question of law involved in the appeal. Kindly see the single ground is in the appeal. I have filed a cross objection. I have challenging the observation of the learned tribunal regarding income the 5,000 per month. So, Lordship, aware that the judgment of the Supreme Court or the Supreme Court decided if there is a confusion, Lordship also note earlier occasion I have placed the judgment. There is the duty of the insurance company to produce the minimum wages. Lordship, can recollect that I have placed this judgment. Lordship, kindly see that the judgment that I am reading once again. Lordship, in the Kumkumi Dhara, that case I have filed where I have placed this judgment. There is the duty of the insurance company. Lordship, put the question. Is the income not proved? Then whose duty to prove the income? The duty of the insurance company to prove the income in view of the Minimum Wages Act. That is the judgment of the apex court.
Citation দেবে একটু
নিশ্চয়ই দেবো
কপি দিও
সব দেবো তোমাকে ভাই Yes, Lordship. এটার কপি নেই Lordship, I'm reading, then I'm handing over. Paragraph 16 that I have cited in the case of Lordship Kumkumi Dhara where the Mr. Chakraborty appeared. We may observe that in general, that is accident involving adults. Let's kindly see that adults. We are often confronted with the situation where the minimum wages data is not readily available, and every so often the question has been made up by this court hinges only on the calculation of income. In view of the matter, and in I hope that reducing claimant need to be filed to appeal to the court or even the High Court. We deem it is proper direct the NCS that claimant is failed to furnish. Let's kindly notice that where the claimant has failed to furnish appropriate details of income or adequate proof thereof. Lordship, kindly see that. It shall be responsibility of and obligation of the contesting party, more particularly specify, more particularly the insurance company to furnish before the tribunal applicable minimum wages and duly insured by the concerned government. They did not discharge their duty on a single occasion. They filed a statutory appeal and Lordship is intending the appeal. Kindly, pardon me for wording this word because of they have right.
No, it is, you are now arguing your counter objection. What is the ground?
But Lordship, 5,000 is considered, it should be more. What will be the more? Lordship, kindly come to the Lordship, the minimum wages that have come to the circular. Lordship, kindly come. This is the van mechanical. There is no rebuttal evidence. Lordship, kindly come to that. So Lordship, kindly get driver or mechanics, 8,685. By time we consider 5,000. Against that, say paper and appeal. Tribunal consider 5,000. Against that, there is the first ground of appeal. The tribunal awarded 11 lakhs by considering the 5,000. That is the first appeal, first ground of appeal. The appeal should be dismissed in limine with cost. Just see. But you kindly see the date of accident. March 2021. Let's see, found the date of accident.
Yes.
20th March 2021.
Yes.
And let's kindly see the circular effective from September 2020 to February 2021. So I am within. But let's kindly consider, forget about the fraction, is 8,500 is a round figure. I was object to correction also, but though it is appearing from the minimum wages act, now it is updated. No rebuttal evidence. Appeal preferred. And there is no scope to conversion to 163A. There is no, because this is the choice, is the option of the claimants to file application under section 166 or
suppose
yes.
The claimant fails to prove the case. Negligence is not proved.
That is the answer. Rosie, kindly see.
No.
Claimants put full.
So in that case, if the case of the claimant is very bad, the negligence is not proved, there is some laches.
Not proved, the charge sheet not submitted. Rosie, kindly.
Whatever it is, if
from
the evidence, if the court is not convinced that the negligence is proved.
In this case, that question doesn't arise.
There is a provision, that is a beneficial provision.
There is a provision, because there is a provision, but it doesn't mean that if in such a situation where the claimant has no papers, nothing, even then you file in under section 166, the petition will not be allowed by the filing court also. The question doesn't arise. But Lordship will say in the final stage. Final how? Because in the preliminary stage, they will not satisfy the court that I have a case. If I have a no case, then I have a no case.
May I say on the
No.
Yes, let him reply then.
And then Lordship kindly come.
So your evidence adduced regarding income, how much? You have filed any slip?
Nothing.
Salary slip or something?
Nothing. I am not a scamp of paper. I am with him. Not a scamp of paper. Nothing I have proved before the Land Tribunal.
Not even his occupation has been not been.
No occupation has been proved. Yes, absolutely, I agree with him. Anything more? I am agree with him. I have made my submission on that score. My land report has not followed. Lordship, kindly see the evidence. Wherefrom I have said that my wife has come before the Land Tribunal and said, this is my husband working as a machine mechanic and he's used to earn 15,000. Against that, no rebuttal evidence. So you can recollect that a submission I have made. What he will say. Nothing paper, not a single paper, not a piece of paper have produced before the Land Tribunal. In such a situation, Minimum Wages Act has to be applied. The judgment of the Supreme Court that I have given to your Lordship. Even though I have a papers of that, then I would not have produced this document before the Lordship. And I will stress on that is that the document is there. Yes, in this case, the wife has come and deposed that yes, my husband is the profession of motor mechanic and used to earn 15,000 per month.
Let him show that he's where he has stated that his husband is a motor mechanic. Let him show from the evidence.
Yes, from the evidence, where is there?
Page 21. Kindly seize my lord.
Page.
Cross examination is my part or your part? You did not put the question, why you will answer?
No, 21. Chief, PW2.
Yes.
PW1.
1.
Yes.
Paragraph 8.
Paragraph 8.
Paragraph 8, page 18. My husband was healthy young. So he is accepting that. If I appeal to show, then he is ready to accept. Very well. So kindly see paragraph 8. My husband was healthy young man and with active habit. He used to earn 15,000 per month from his said occupation as expert body mystery of mechanic van of Vishwakarma engineering works and such and such, whatever. That evidence is there, the affirmation is there. And Lordship kindly see the cross examination. The did not put a single question on that issue. Lordship knows the oral evidence as a piece of evidence. Kindly come with a single question they have put. They accepted that. No rebuttal evidence. Even then, prefer an appeal without evidence. How the appeal will be maintainable? Even then, is it reserve a right to a reply?
Yes, I have a right to reply.
Exactly, I have said that you reserve. See that what is their cross examination? Just kindly look into that. My case filed against the offending vehicle, but they are running behind my vehicle. Just trying to misleading the court. Here also said that A166 can be converted in the appeal court after that evidence can be converted to the 160. That he is also submitting in such way. Aware of that is not possible.
Supreme Court. Minimum wages act. Minimum wages.
যেমন লাগবে এরকম দাগ দেওয়া আছে লিখে নাও না এটা অ্যাপিল নাম্বারটা লিখে নাও না তাহলে ঝামেলা
Yes.
And Lordship, the judgment I have placing before your Lordship, Hitesh Ji, this commonly Hitesh Ji, that judgment here, Lordship, that there is no income. How the Supreme Court dealt with the issue? This is the injury case, but how dealt with the issue? If no income, then Supreme Court did not convert the case to the 60 day. Address the readdress the address of the applicant on under 166.
Now, in cross-examination, what is the statement of this
Lordship?
Cross-examination.
Yes, page 21, Lordship.
Yes, page 21.
Yes,
okay, work at Vishwakarma Engineering Works.
Yes, my husband used to work at the Vishwakarma Engineering Works at Bardora. तो गिरी की है गिरी ना BIDI वाला गिरी उच्चारण की है BIDI
No, you see, regarding public motor transport, this is applicable. Okay. So what is this? This is a.
It's a public. This
no, Vishwakarma Engineering Works. It is a place for repair.
Yes.
the place for repair.
Yes.
But you see,
Lordship.
cleaners and lorry coolies, it must be related to that vehicle. Fitters, timekeepers, it should be related to the vehicle. Driver, mechanics, related to the vehicle. There must be a particular vehicle. In that particular vehicle.
Vehicle, Lordship. That is the someone mechanics. I am the driver, so I can drive all the cars. It is not my driving license, not for the particular
But you
vehicle.
see, the mechanic is engaged. You see, all transport operators, owners engage a mechanic, a driver, fitters. So many persons are engaged.
Lordship, here,
So what is this? This is a engineering work, some type of repair shop.
When the proprietor also not came and
No, that's I'm forgetting about that. Had he been employed in any transport vehicle, that would have been one thing, definitely. But engineering works means one type of repair shop. So all these repairing works are going on.
The minimum wages, employment of public motor in the West Bengal.
Yes, a public motor transport.
Very well, Lordship. This is the minimum. What is the concept of minimum wages? The minimum wages means you cannot pay less than that.
Is this person engaged in any public motor transport?
Lordship,
He is engaged in any repair shop.
Lordship,
Okay, there are so many garage repair shops.
The minimum wages. Lordship, kindly, I kindly allow me.
No. Let us understand
Lordship,
the meaning.
Let allow me.
What is the interpretation of this?
I may be wrong, Lordship. I may be wrong. Minimum wages means the wages not to be paid less than the wages as decided by the government. There is the government decided a mechanical wages 8,685. That is decided by the government. So whatever in wherever we are work, my wages cannot be less than that. That is the spirit of the minimum wages.
Public transport vehicle is one thing. Suppose, but in your car you engage a driver.
Lordship,
this is not applicable.
Cannot.
No, in your personal vehicle, you engage a driver. And you say that this 8658 is that will not apply as a public transport.
Absolutely apply, Lordship.
How public motor transport?
No, Lordship.
In your private vehicle, you engage with this apply.
Absolutely, minimum wages. I have to follow the minimum wages act, but I cannot pay
here
less than that.
Should not be applicable since Mr. Rai resigned.
No.
Here, my God, in the
public transport definitely. But suppose your vehicle, you are engaging your driver. It is not a public transport.
Not public transport.
So
this judgment will not be applicable. May I say, my lord? In this
this circular.
In this judgment, my lord, minor was
not minor.
Obviously, it was a minor. What is he saying? The judgment says that minor, his income could not be ascertained. That is the reason minimum wages was considered.
Kindly allow me to talk with my learned senior friend, Lordship. এখানে প্যারাগ্রাফ 16টা পড়ো বস বুঝেছো?
2 নম্বর প্যারাগ্রাফে পড়ো
না ওটা পড়বো কেন কি মুশকিল পড়বো না তো ওটা আমি kindly see no we may also observe that in general that is accident involving adults we often conform it is a situation না পড়েই কথা বলছো জাজমেন্ট এটা পড়তে
anyway you are
বসো তুমি
তোমার থেকে শিখবো থেকে
now the you are relying upon this two decision and this government circular.
But Lordship, my humble submission is that I have engaged a driver. I cannot pay less than that amount because this is the minimum wages.
You see,
I can pay more than that, but not less than that.
Minimum wages for certain categories. Okay.
All categories, Lordship. Even if the.
So what is the distinction between public and private vehicle?
Not private and public vehicle, but once he's working under me, this means he is a public vehicle. He is the private vehicle, public. There is no difference. There is no difference, Lordship, because of the government decided that once you have engaged some person who should not pay less than that amount. That is the minimum wages act. You may more than that, but not less than that. That is the minimum. This is the spirit of the law. That is the spirit of the law. Now, how the Supreme Court has come to a conclusion, Lordship, kindly see that. Kindly see that the insurance component to furnish before the tribunal applicable minimum wages. Why the Supreme Court said so? Why Supreme Court said so? Lordship, here the case is the injury case. Even then, Lordship, paragraph 16, we may also kindly come to paragraph 16, Lordship.
Which judgment? Okay, one is our High Court. Yes, Bangalore Metropolitan.
No, Lordship, the judgment I did not hand it over. The Hitesh judgment that I have given. Paragraph 16. Paragraph 16, this is the case of minors. After considering the minors case, the Supreme Court come to observation, kindly paragraph 16. We may also observe that in general, that is accidents involving adults.
Page 16.
Paragraph 16.
Paragraph 16. Yes.
The case filed before the Supreme Court is the case of injury of minor children. After that, Supreme Court come to a conclusion, paragraph 16, we may also observe that in general, that is accidents involving adults, we often confront the situation where the minimum wages data is not readily available. Every so often, the question that has been made up to this court hinges only on the calculation of income. In that view, the matter and the hope and reducing the claimant needs to file the appeal. Let you kindly see, in such a situation, if that is the minimum is not considered, in view of the matter, in the hope for reducing claimant to need to file an appeal to the High Court, to this court or even High Court. Let you kindly mark it, kindly note it. If not minimum wages considered, then matter can be filed before the High Court or even with the Supreme Court. We deem it proper, we deem it appropriate to direct the case where the claimant has failed to furnish the appropriate details of income or adequate.
Yes, which paragraph 17?
Yes, paragraph 17.
Which paragraph 17?
No, continuing. I am continuing paragraph 16.
Yes.
Next page. Has you got it?
Yes.
This court means Supreme Court or even the High Court. We deem it appropriate to direct that in case where the claimant has failed to furnish the appropriate details of income, that is a submission, Mr. Bhattacharya, not a sheet of papers, single papers, no papers, nothing papers, that is submission. Income, adequate proof thereof, it shall be responsibility or obligation of the contesting party. Let's kindly see who are the contesting party? Insurance with the contesting party. Let's kindly see. More particularly, specify the insurance company to furnish before the tribunal that the applicable minimum wages duly issued by the concerned government. There is a government issued this minimum wages. What apart from that, what papers issued by the government? This is the government paper. Issued by the concerned government. The state government papers I have placed.
By applying the principles of pronotiety, 5,000 is not.
Pronotiety, there is no law of 5,000. Pronotiety, there is no indication of 5,000.
No, notional income.
Notional income, pronotiety case not decided loss in income. Pronotiety never, pronotiety never is decided the income. Income is not decided. Mood of ratio decided. In Sholahoma and pronotiety, difference is the one line difference. Sholahoma said, same 29%, not entitled. Future prospect. Pronotiety said, yes, entitled. And what is the mood of calculation? That is the pronotiety. So, lordship, whatever the calculation lordship will given, then in view of the pronotiety never indicated lordship the income. Never, nowhere in indicating the income. 5,000, 2,000, 1,000, never indicated. What is the income? That income has to be proved. If not proved, Supreme Court said, minimum wages said, has to be followed as duly issued by the concerned government. The concerned, that is the state government, our concerned government. So, what more certificate I will procure? Who will issue the certificate? Lordship will put the question, public vehicle or private vehicle. Then from the private vehicle, who will issue the document? I have any right to make any circular to the public. So I have to abide by that. That is the judgment. Specific, no more particular the insurance company to furnish before the tribunal. That is the specific. Even then said, if not land tribunal considered, come to this court, Supreme Court, or come before the Honorable High Court. That is the language. Can you see that?
Yes.
What is language? Claimant needs to file appeal. Let's kindly see, in view of the matter and in the hope for reducing the claimants. They reduce, did not consider the Minimum Wages Act. Reducing, the claimant needs to file appeal to this court or even the High Court. That is the judgment under Article 141 that cannot be. And what is the furnish the applicable minimum wages are duly issued by the concerned government. That is the state government or concerned government.
Yes, let us see. Let us consider the judgments and your circular. Yes, any other decisions to be cited?
No, more or less, I have already cited the decision because of there is no evidence.
Yes.
And lordship, one thing is that just kindly see the first paragraph 3. Just see. Since eyewitness not produced, tribunal it was 10. আরে ভাই আমাদের একটা ভাগ্য প্রত্যেকে 80 বলো আমরা নিষেধ করে দেবো কয়েকটা হ্যাঁ রাজ্যে কি মেয়ে রাখো নিষেধ করবে আছে so kindly see lordship also the observation that ration negligency Just kindly, just I'm reading, Lordship. I have one, Mr. Bhattacharya. In an accident which took place on such and such, Ramkin was alleged to have been hit by the bus leading to his death. And FIR was lodged wherein charge sheet was submitted. Lordship, here charge sheet submitted against the driver of the bus. On the claim being preferred to the Motor Accident Claims Tribunal, since the eyewitness were not produced, they are produced. The tribunal refused to grant any compensation decision tribunal upheld by the High Court. Once charge sheet has been produced, then national negligence proved and the offending is liable. There is no way to escape their liability, the legal liability. No way. Because of there is no evidence adduced by the parties.
Yes, continue after 2.
2 p.m. I have some difficulty. 2 I have very.
More or less, you have completed.
Anyway, what you submit?
On the issue, my lord, of the income, my lord, kindly sees the claim application.
একটা কথা বলি, my lord, claim application, evidence.
Okay, please.
No, I'm with Mr. Bhattacharya. I'm with concern Mr. Bhattacharya.
No,
whatever he submits, let him
I am
submit.
not given anybody any consent, my lord.
Yes.
Don't take it otherwise.
No, follow na.
Kindly sees my the claim application. He addresses that while he is working, Vishwakarma engineering work proprietor, so and so. If my lord sees, my lord.
Okay, paragraph
5.
Yes, 23. Okay.
Paragraph 5.
No.
Paragraph 5. Yes.
Claim application, first page. Page 1.
Page 1. Yes.
Kindly sees, my lord, name and address and employer of the deceased.
Yes.
Now, my lord, kindly sees the income portion. At page cross-examination 21.
Page 21.
Income portion has admitted that.
I have not admitted that once. This is not a manner of
page
very
21. Yes.
This is your manner.
Page 21. Yes.
Kindly sees page 21, my lord.
Yes.
The wife only comes and make a statement in cross-examination that my husband used to work in so and so. The proprietor has not come. Not a single scrap of paper produced in support of the income. And my lord, the Honorable Supreme Court judgment which Mr. Rai is resigning, it's on a different facts, the minor case.
Oh. এটা কেন বলছো এটা তুমি ঠিক করে বলো না it is the case of minor injury case.
I shall see whatever the case deals with. I shall consider.
No,
whatever is the relevant provision, whatever is the relevant portion in the deposition, let him submit that.
Yes, let him submit that. Yes.
Kindly sees my husband used to work at so and so.
Anyway, very well. Yes, you have submitted that the employer was not examined, no documents furnished. Simpliciter only the name of the concern is given. So that is why
even what was the nature of work, if he was a licensed person, if he was a professional person, supporting document of such profession should be given.
Yes, so according to you, the learned trial court rightly assessed the income to be 5,000. Anyway, in his support, your learned friend has submitted some judicial decisions that will be considered.
That was on a different aspect.
Very well, let me see that.
Paragraph 2 is the minor's income.
Is the minor's case, I'm submitting that. It's the case of minor. Kindly minor.
Consider
to paragraph 15. Let's kindly mark it in the judgment. Up to paragraph 15 is the minor. Thereafter, case decided for adults. Kindly see that. That word used, adults. We often confront with the situation or minimum adults.
So that is an obiter dictum, that portion.
No, not obiter dictum. This is a basic situation.
No. You see, a case, a judgment is a precedent on the facts what it decides, not whatever is said there.
In the minor case also the minimum wages has considered.
Judgment has
in the minor case, very well. Also kindly read the entire judgment because of if he is not able not read the judgment. Just
he has not provided. Difficulty is Mr. Rai is making entire submission.
Anyway, whatever is relevant, you have.
He is the appellant. I will provide the judgment.
Obviously, you are resigning the judgment.
You have also your own appeal.
Yeah, I have also own appeal.
You have submitted 2 decisions Two of the Honorable Supreme Court, one of our High Court,
Lordship.
and the circular of the state government.
Lordship.
Oh, very well. Yes, record and order.
And Lordship, the 40,000, 140,000 is 240,000 will be granted. The judgment is pending before your Lordship.
Yes.
Consortium, here the
1,40,000 is granted.
Not 1,40,000, Lordship.
No, here the what consortium is the husband.
No. These are all legal heirs. Husband, minor, daughter, son, all are 4 claimants are there.
Okay, 40,000 is granted.
140,000 granted, should be granted 4. That is pending. That argument I have advanced before your Lordship. That ground I have taken.
Anyway, that I shall consider.
Your Lordship, kindly note that Lordship will consider.
From the record itself, if the court finds that whatever consortium is granted is reasonable, the court will not enter into that.
Point apart, I'm challenging. Court consider 140,000. It should be granted 4. That is the ground.
Very well. You see, there are decisions. You see, in another matter, I have reserved a judgment also.
Yes,
okay. In another matter,
yes.
I shall decide after that. Okay.
Lordship.
Thereafter, I shall consider. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. CAB.
Pitha is required to hand over further, or to already have handed over.
Yes, which case?
40,000 consortium.
40,000?
If he hands over, let us copy
Yes, you can give it.
No, they already have given.
No, I have.
Yes, in this case.
No, another case.
In this way,
No, consortium case.
In
Consortium.
Yes. That argument advanced by Mr. Singh, also advanced.
I was not there.
In that matter, probably you are not appearing.
Yes. One matter I have appeared.
Anyway, you give a copy to your learned friend also.
Lordship, I am supplying
But in that event, I shall be arguing on that issue. If he places something,
if you want, you can give a written note.
এখানে নাই মানে পার্টি দিছি আমি পার্টি চাই ক্যান টু বোধহয়
এরা করে চলে গেল
বইটা কোথায়?
একটা
ওই একটা
বলছে আমার একটা
পাসওয়ার্ড মাথাটা ডেকে দিন তাহলে
item number 7 and 8.
yes give the
Yeah.
records
7 is my appeal, my lord, and 8 is my learned friend's separate appeal.
Separate appeal.
I have preferred this appeal, my lord, only on the point of interest. Learned tribunal judge had granted 6% simple interest, and we were directed, the insurance company was directed to pay the awarded sum within 2 months. In default, 9% was awarded from the date of filing till realization. That 9%, my lord, we have preferred that an appeal, my lord, for reduction of that rate of interest, my lord. I pray that my lord will
9% from the date of default.
filing.
Okay, from the date of filing.
Filing. This is my one ground. Another ground I have taken, my lord, it's non-involvement. My
Exempted.
non-involvement ground I have taken. My learned friend has the accident, my lord, it took place on 1st of December 2019, and the FIR was lodged, my lord, after 2 days, my lord. So, in view of the judgment of Ravi versus Badrinarayan, this goes against me. My learned friend will be citing that. We have sent it to get a photocopy done. 95. 95 আর 1197 দুটোই একটা আমার appeal একটা ওনার appeal. In view of the judgment,
Your point of appeal is confined to interest.
Interest and non-involvement, one ground I have taken additionally because the FIR was lodged after 2 days.
After?
2 days. But that ground, my lord will.
Now the question of default is this: if you have preferred an appeal and obtained a stay, then it will not be counted as default. Within how many days you have preferred this appeal? That is the question. So long you see, you have
After the statutory period.
Statutory period.
But there was no delay.
Yes.
No, there was
you
a
have-
delay. There was a delay, which was then thereafter it was condoned.
Yes. So actually,
I have deposited with 9%.
you have deposited with 9%
My
right
lord.
from the.
Date of filing. So whatever with 6.
See, even if it is default, the argument is this: the moment an appeal is filed, it cannot be said to be a default. Appeal is filed, stay is granted, then the question of default does not arise.
But one thing, my lord, default interest in Motor Vehicles Act, my lord, there is no provision of payment of this word default. It doesn't exist. So it's only
So
simple
6%.
interest.
So the period for payment was how many?
From the date of filing, I'll give the
No. Period of payment 1 month or 2 months?
No, within 2 months.
Within 2 months.
Within 2 months.
And within 2 months you file this appeal.
No. After that. Award was passed on 8th of July 2024. I filed it on in sometime in November.
Anyway, let me hear the appellant, Clement.
He is agreeable. I've spoken to him. But my lord will.
My lord.
Yes, what?
My lord, my appeal, my lord, only one short point involved, my lord. Learned tribunal, my lord, not granted interest from date of filing till realization, my lord. That, my lord, only, my lord, exempted from paying interest from the period of between 25th April 2020 and 31st December 2021 due
So
to
let me see the
COVID-19
award.
period. This is, my lord, only one point, my lord.
Yes,
I
what
am
is-
paying, my lord.
Just a minute. Yes, the interest awarded is.
Yes, the ordering portion, my lord will see. Page 8 of the award.
Yes, page 8.
Page 8. Page 8, my lord, it's middle portion, the OP number 2, Oriental Insurance Company Limited is directed to pay a sum of rupees 10 lakhs to petitioner number 1, 20 lakh each to petitioner number 2 and petitioner number 3. Then thereafter, after the one line, within 2 months from this day, along with 6% interest from the date of filing of the instant application till realization of the award, failing which Oriental Insurance Company Limited is further liable to pay awarded amount at the rate of 9% per annum from the date of filing of the instant case.
No,
On
the
the said
question
amount,
is,
my lord,
the interest is granted 6% per annum from the date of filing of this application till realization.
till realization.
So that is there.
That is, we did
No,
not.
that is there.
Yes.
With regard to your
Yes,
appeal,
yes.
this excess 9% is granted.
Excess 9% is.
Yes. So what is your grievance with regard to this award?
Thereafter, this COVID period has been.
My lord, last portion, my lord, para 2, my lord, 9% per annum from the date of filing of the instant case of the said amount till the realization payment.
Yes, that
However,
is the default. That is suppose if they don't pay 9% per annum from the date of filing of the instant case. Yes, failing which, that means if they don't pay it within 2 months, they will be liable to pay 9%.
Yes.
So that is why they have preferred this appeal, as well as there is another ground regarding involvement of the vehicle on the ground of delay of the.
May I assist my?
However, my lord,
the next line is his grievance.
however, opposite party
However,
number
is
2
exempted.
is
That
exempted from paying.
Exempted portion, that is his grievance.
Okay.
This is my point, my lord, only.
He is paying it from the date of filing till realization without any exemption.
The order is passed on 2024.
Date of filing হচ্ছে
So that period, that is 1 year, 1.5 year, that exemption is given.
Yes.
Yes, madam.
He's praying for a direction from my lord that the interest should be from the date of filing simply till the date of realization, nothing. And I am
How long is it?
refund of the.
So this case was instituted during this COVID period.
It's yes. It's a MACC of 2020.
That means during the
32
COVID
of 2020.
30 of 2020.
MACC case
Actually,
now.
took place in 19 December on 19. It took place, but the
As December 2019.
claim case was instituted during COVID period. Only one line from my lord, that my lord will grant us liberty to withdraw the balance amount, and the claimants are entitled to interest at the rate of 6% from the date of filing till realization.
Yes, record and order.
And regarding that non-involvement, that judgment, my lord, because there's 2 days delay, my lord, that my lord may.
Yes, learned advocates for the parties are present. The appellant in FMA 95 of 2025, the Oriental Insurance Company Limited is opposite party number 2. Is opposite party number 2 in MACC case number 32 of 2020 before learned additional district judge, Third Court, Krishnanagar, Nadia. The appellant insurance company being aggrieved by the award dated 8th day of July 2024 passed by the learned additional district judge, Third Court, Krishnanagar, Nadia in MSC number 32 of 2020 has come up with the instant appeal. The ground for challenge in this appeal is that the learned trial court did not consider as to whether the vehicle was involved or not,
Paragraph 20, this is the portion I was
and
referring.
came to a findings about the involvement of the vehicle, although there is delay in lodging the FIR. Stop. It is the another ground on which this award is assailed is that the appellant insurance company was directed to pay interest at the rate of 9% per annum from the date of filing of the instant case on the said amount, on the said awarded amount, till realization of payment. In the event the appellant insurance company fails to pay the awarded sum within 2 months from the date of the award, the claimant, in FMA 1197 of 2025, the claimants, the appellants were the claimants in MACC case number 32 of 2020 before learned additional district judge, 3rd Court, Krishnanagar, Nodia, and is aggrieved by the award dated 8th day of July 2024, in which the learned trial judge exempted the opposite party insurance company from paying interest from the period between 25/4/2020 and 31/12/2021 due to COVID-19 pandemic. Stop. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that with regard to the delay in lodging of the FIR, can be no ground for dismissing the complaint case and by disbelieving the case made out in the FIR. In this regard, the decision of Dalveer Bhandari, in the decision of
Ravi versus Badrinarayan.
Ravi versus
Badrinarayan.
Badrinarayan and others may be taken into consideration. In the decision, in the said decision, the Honorable Supreme Court observed as follows. Set out para 20. Thus, upon considering the decision of the Honorable Supreme Court and considering the facts of the case, the arguments of the appellant insurance company cannot be sustained. However, with regard to the submission of the learned advocate for the appellant insurance company that her client was directed to pay 9% of interest in the case of default if in making payment within 2 months, this court is of the view that as the provision of default interest is neither in the statute nor is there any terms in the contract of insurance which the claimants could produce, and further the appellants have preferred an appeal and obtained an order of stay, the direction to pay the default interest cannot be sustained. Thus, the amount directed to be paid on account of default is set aside.
Grateful, Madam.
Now, with regard to the submission of the appellant in FMA 1197 of 2025, who are the claimants in the before the learned trial court, this court is of the view that the motor vehicles claim legislation being a welfare legislation and the case being instituted during the COVID period and heard also during the said period, the learned trial court ought not to have exempted payment for the period of 25/4/2020 and 31/12/2021. Thus, this order of the learned trial court also cannot be sustained, and the same is set aside. Thus, the claimants, appellants, Bondana Bishwas, Udayan Bishwas, Bidisha Bishwas, Minirani Bishwas will be entitled to withdraw the principal sum awarded by the learned trial court.
5297992.
No, but just a minute.
My lord.
I have mentioned the name of the appellant's claimants.
I'm sorry. I'm sorry. Yes.
Sum awarded by the learned trial court, along with interest at the rate of 6% per annum from the date of filing till the date of realization, as it is submitted by the learned advocate for the appellant, that the appellant has already deposited the principal sum along with interest at the rate of 9% per annum from the date of filing till realization, the appellant insurance company are permitted to withdraw the excess amount after the respondents, claimants, have withdrawn the principal sum awarded by the learned trial court along with interest at the rate of 6% per annum from the date of filing till the date of realization. Thus, both the appeals, FMA 95 of 2025, FM and FMA 1197 of 2025 stands disposed. The Registrar General High Court Calcutta is requested to permit both the parties to withdraw the amount in terms of this order upon submission of relevant documents and upon compliance of the relevant rules.
I'm grateful, my lord. Only one thing, my lord, wherein my lord had directed the claimants to withdraw. My lord had provided the name. If the principal amount along with 6% interest.
Yes, from the date of filing till realization.
If that can be mentioned.
I've mentioned
the
it there.
principal amount of rupees 52 lakh, that whatever has been awarded by the tribunal, if that can be mentioned.
Amount of rupees 52 lakhs.
5297992.
Okay, legal.
5297992. Along with 6% interest.
Yes. Okay. With regard to the proportionate sum which is awarded with respect of the claimants, the learned trial judge's order shall prevail.
I'm deeply obliged, my lord.
With regard to the proportionate amount of payments of compensation to the claimants, the order passed by the learned trial judge shall be applicable.
Grateful, my lord. Grateful.
Your Lordship, this is my appeal.
I am for the respondent.
Your Lordship,
I filed it cross appeal and paper book last occasion.
Where is that cross appeal?
Cross appeal is in the paper book, Your Lordship.
No, it is not appearing.
Yes.
This is item 14.
No, Your Lordship. It's item 14. Item 14, Your Lordship.
What show na করলে ওর সঙ্গে আছে
লিস্টে সই করছেন। এনিওয়ে পার্টিজরা আছে যখন ট্রিট করে নেওয়া হয়। হ্যাঁ, না আবার নেক্সট ডেটে করতে হবে।
Your Lordship, there are two grounds of appeal, Your Lordship. The first ground is Your Lordship will find from the impugned judgment, which is at page page বলুন তো পেপার বুকের পেজটা বলুন। 24, Your Lordship. 24, no? 20.
24 to 29.
That's 24 is my appeal, Your Lordship. On the first ground of appeal is, Your Lordship, in the impugned judgment, it will be found that the father has also been considered as the dependent of the deceased, which we have appealed and said it shouldn't be 1/4, the deduction has to be 1/3. In case of deduction, which the learned court has considered as 1/4, Your Lordship, that will be evident from the page 21, running page 21 of the, when the learned court below has deducted 1/4 of the income of the deceased, which should be 1/3 according to us, I mean the insurance company, because the dependents are the wife, the minor daughter, and the mother of the deceased. And father shouldn't be considered as a dependent, as the father is a self-sufficient person. And another point of appeal,
person means the father was claimed to be a defendant.
yeah, father has been claimed to be a defendant, which
depends upon the facts of the case.
Yes, facts of the case, Your Lordship, and here always, Your Lordship, and in this case, the claimant has not proved beyond doubt that the father is dependent upon the deceased herein, Your Lordship. And Your Lordship, the another point of appeal is, Your Lordship, the consortium, the total consortium, running page 21, Your Lordship will find the loss of consortium has been awarded as 1,60,000, which should be 40,000 as per to the judgment. I am citing the judgment for you, Lordship. When is there's the coordinate bench judgment of this court only. Bonusri Banerjee judgment data. Bonusri Banerjee. না এখানকার coordinate বিভাস পটনায়ক। Your Lordship, the herein.
Yes, this is a unmarried person.
No, married person. Married person. So, Lordship, the appeal is in a ground of only twofold, Your Lordship. And in respect, we have in the grounds, there is another ground which you have taken as of liability, which I will not press, Your Lordship, because the insurance company has not done sufficient evidence before the learned lower court to prove that the car was not liable. So that I have taken the ground, but I am not pressing it. Your Lordship will take a note of it and will pass necessary order to that effect. But the main two grounds,
the challenge is loss of consortium.
Loss of consortium should be 40,000. Funeral expenses, loss of estate is fine, Your Lordship, 1515. But this 1,60,000, wherein the learned trial court has done a mistake of has multiplied with 4, which is not allowed as per to the prevalent law and as per to the prevalent citations which I have given, Your Lordship. And also, Your Lordship, the deduction in respect to the deceased should be 1/3, as the claimant were not able to prove that the father is a dependent upon the deceased herein. And Your Lordship,
that deduction and this consortium,
nothing else, Your Lordship.
That's all?
That's all.
Yes, sir.
Now, my lord, may I submit the factual aspects of this case? Here the claimants are the 4 numbers: the wife, minor son, mother and father.
Yes.
Wife, minor son, and my lord, the mother and father. Now, my lord, the accident took place on 5th January 2023. Offering vehicle is a light goods vehicle, which dashed the victim, my lord, while he was returning to home after doing my lord. Now, my lord, the victim disease was a
Yes.
My lord, victim disease was my 31 years old. 16 multiplier, my lord, used by the multiplier. That is correct. I have no dispute. But regarding my lord income, my lord, we claim 9,000. My lord, since my lord victim was a my lord is a labor of a leather shop of engineering. That was stated by the wife. Though, my lord, there are no documentary evidence.
In the claim application, your lordship kindly see
Employee of leather shop.
yes. My lord, column number 3, occupation of the victim, leather workshop, engineering workshop.
That
And
is
my lord,
page.
he paid page 1 of that is claim application, and page 2, the income which was shown as 9,000 per month.
So incident, date of incident?
Date of incident on 5th January 2023.
Okay, 9,000 per month.
Evening, my lord, 3,000, my lord, a skid, my lord, he was a 300.
Okay, how much is the notional income assessed by the court?
5,000.
5,000.
5,000.
That was too, my lord, the my lord, meager
Is
fee.
the relevant law, your lordship? In High Court, we follow. This is Justice Shonji Banerjee's order, your lordship.
No,
Where from?
আমাকে বলতে দে, তোর তো বলা হয়েছে।
বলছি, ওটা জিজ্ঞেস করুন ওর সাথে।
বলছি তো।
বলেছি কি?
My lord, wife says that my husband used to earn rupees 9,000 by doing, my lord, work from a leather engineering shop. My lord, that was not controverted by the insurance company by adducing or producing any documentary or, my lord, the
So this
oral evidence.
proprietor was not examined.
Proprietor, there is no evidence.
Any
Only oral evidence.
any pay slip filed?
No.
Nothing has. Nothing.
My lord, your lordship kindly see, my lord, your lordship, my lord, seeing, my lord, after
No, work in leather shop.
but that was not, my lord, contradicted or, my lord, the objected by the insurance company when the, my lord, the wife of the deceased, my lord, deposed. Any question, my lord, raised by the, my lord, the insurance company,
Future prospect taken into consideration.
future prospect taken into consideration. And, my lord, third point which my learned friend, my lord, second point which my learned friend says, that since, my lord, the father was not a dependent.
I need to interrupt because I do not shall the page 9, the deposition of the wife of the deceased, your lordship.
Yes.
বলেছি তো আমি।
আরে তো আপনি বলছেন নেই কিছু, তাই দেখিয়ে দিচ্ছি একবার।
আরে আমি তো সবই দেখাচ্ছি তো জজ সাহেবকে, তোমার তো বলা হয়েছে তো।
শর্টে একটু করে দিন।
তুমি তো রিপ্লাই দিতে পারো।
Anyway.
The deposition should be put forth, your lordship.
Anyway, let him submit. Thereafter,
Yes,
do you reply?
Now, my lord, your lordship kindly see, there are two grounds, my lord, the insurance company taken. First, the deduction should be, my lord, 1/3 instead of 1/4. Since the father is not a dependent and since father will not come as a claimant. This is the first point. Second point is, my lord, the parental and filial consortium, the 1,60,000 was granted. But the learned tribunal, my lord, while passing the award, granted, my lord, funeral expenses, loss of estate, 15,000, and consortium. That, my lord, the judgment, that matter was argued before your lordship, and it
You
is
have
active.
cited only one judgment. I think in another case you have cited some.
Yes. That is the case of a, my lord, the minor girl. But here is a major. My lord, I have brought, my lord, some decisions where the father, my lord, now, my lord, my cross up. What are my grounds in my cross appeal? The income, my lord, in my cross appeal. In my cross appeal, my lord, there are, I have taken, my lord, 3 grounds that the income should be assessed as 9,000 or 9,560 as per the minimum wages. Because
Wages of what?
minimum wages.
You have that circular government?
Yes,
circular?
yes. I have circular. Because the Supreme Court, my lord, on several occasions, your lordship kindly see. My lord, your lordship kindly turn to column number 20. Leather goods manufacture.
No, this is a manufacturing factory or just shop?
No, my lord.
Leather goods manufacturing.
Manufacturing.
Okay, manufacturing is one thing and shop and establishment is another thing.
Yes, my lord, he says, my lord, he was working in a manufacturing working shop. Manufacturing. Your lordship kindly see my notifications on the relevant date. Relevant date is, my lord, that I have given the circular. That was, my lord, circular dated the January 23 and 30th June 23. The accident took
Just
place.
a minute. You see, while of the workshop.
Your lordship see my notification. 20.
Yes. So,
my lord, your lordship kindly turn to column number 20 in my notification, which I have handed over. That semi-skill. My lord, I am not taking the skill. Well, highly skilled.
taking yourself as unskilled.
No, unskilled, no, semi-skilled.
It should be unskilled.
Because you have not stated what was the nature of the work.
Nature of the work, my lord, he was doing a, my lord, your lordship kindly see a leather, my lord, manufacturing shop. What the, my lord, the worker does, either cutting or, my lord, doing, my lord, the shops. That was not explained. But the circular says in 3 categories that unskilled.
Leather goods.
Unskilled, my lord, that is, my lord, the unskilled, my lord, that is a labor. Unskilled, but he has no skill. But my lord, the insurance company has not put any questions that any, only question is there any evidence? But my lord, I'm stressing upon the semi-skill. That was reflected is 9,562. Kindly see my notification. 9,563. That is, my lord.
Your notification 9,784. Leather goods manufacturing.
Yes. Column number 20. Third. Semi-skill. 9,562.
No, here it is stated 10,763.
10,000, that is my skill.
Semi-skilled.
Semi-skill is, my lord, 9,560.
Where do you get that? Which column?
Column 20.
Column 20, unskilled is peon, cleaner, sweeper, security man, checking man, packing man, production
Yes.
packer.
Second one is semi-skill, helper of Karigor, sticker, and switcher and labor. That was
10763.
10,000 total, 4,400.
No, it's not telling with me.
My lord, 10. I'm taking 9,562.
Where do I get that? 9,000. Okay, that is
page.
Okay, per month.
9,560.
It is zone B.
Zone B. Yes. Zone A, Zone B.
Yes, 9,562.
Acha. Malad, that was 362 into 30. 368 per day into 30. It comes 9,562. Claim is, my lord, 9,000. My lord, your lordship is ours. Even if claim amount is, my lord, lesser, what is
How
the
much you have claimed? Total claim?
Total claim, my lord, his my lord wife, this is wife says my husband used to earn rupees 9,000. But my lord, there is no documentary evidence as come out from the my lord, the cross examination by the insurance company. My lord, I am relying on some decision of the Supreme Court that was
The incident took place on 2023.
2023 and the notification is January 23 to June to the relevant time. Your Lordship kindly see the notification dated 1st January 2023 to 30th January 2023. On that day, my lord, a semi-skilled my lord worker or the job worker, my lord, how much he used to earn, that was reflected, my lord, in that notifications. So, my lord, my income 5,000 is a meager amount, which learned friend, my lord, has arbitrarily decided. That was in my cross appeal first point. The income should be 9,562. On the basis of the 9,562, learned tribunal ought to be assessed. Now, my lord, second ground, whether the father, my lord, is a dependent or whether father can be, my lord, claiming to file claim application or entitled to get compensation.
What is it? There's a typographical mistake in this thing, claim petition.
In the
What
claim,
workshop?
well, yes, typographical mistake. It's a leather workshop.
The spelling is not correct.
Yes, it was typographical mistake,
They have
but
mistakenly added engineer's workshop as well.
in a leather shop.
He has stated latte workshop.
No.
What is state? It's very difficult to understand.
My lord, your lordship, kindly see the cross-examination.
Yes, cross-examination. What is there?
Page 9. The evidence in chief is starting from page 6.
My lord, page 9.
Page 9. 9 is the cross-examination.
No. 10 is a cross-examination.
Yes. 9 is there, he has stated.
Your Lordship, chief is starting at page 6. Chief. The
Yes,
evidence
I've
in
gone
chief.
through that.
Your Lordship, the para 5. Para 5 wherein he has stated about the work of the deceased. That my husband was a mechanics of a lathe workshop.
lathe machine बोले
Lathe.
lathe machine. It is an English word.
Leather.
Milord, lathe machine, milord, is a small, milord, household workshops, milord, wherein
Lathe bana malada.
one fixed, milord, the tool is there, and milord, by rotating, milord, by wooden or plastic or milord, the iron materials are being made. This is called lathe machine, L-A-T-H-E.
Yes.
It's not leather.
Yes, Your Lordship.
Yes, where is the circular regarding lead machine? Notification? You see, you according to you it is leather, but according to your client that is claimant it is something else. So you see if there is any circular with regard to
Yes,
that.
I'm এটা কোথায় কোন সময় হুম my lord, even assuming, my lord, he's a family man, my lord, he maintained the family man. My lord, if your lordship kindly see, my lord, in 2023, এটা একটু দেবেন জজ সাহেবকে
No,
একটু
no, you
দিন
come with that, a hard copy.
No, my lord, your lordship kindly take this, my lord, my matter as 3,000 because 3,000 is not 300. 300 into 30 days comes to 9,000. That was claimed by the wife. That was claimed by in the claim applications. So on the basis of 9,000, your lordship kindly assess the compensation. But 5,000, the learned tribunal which was assessed, notion income is that was arbitrary.
How many dependents? Wife, mother, children?
And 4 dependents, wife, minor son, and my lord, the father and mother. 300 rupees, 300. My lord, in Lakshmi, Muhammad Sabbar, which was accident took place 2004 and decided in 2008. My lord, our High Court judgment in 2002. My lord, minimum income of an unskilled laborer would be 9,000. That was given by the division presided over Hovistanon and the human church. That was that will be argued, my lord, in another case, my lord, in case. But my lord, since my claim is, my lord, 9,000, which is, my lord, you have to only consider 300 rupees. This is one ground I have taken in my cross appeal. And second ground is, my lord, that the father is also, father is, my lord, you, my lord, not dependent, or dependent. He come, my lord, under the ambit of, my lord, 166. Because 166 of the motor vehicle says, my lord, who are the claimants? Claimants are the legal representatives, not legal heirs. And even Motor Vehicle Act does not say, particularly, my lord, personal law, the Hindu law or the Mohammedan law. Your lordship kindly see 166 বইটা দিয়ে আমাকে 166
একটা সাহেবকে দেখি
Hindu succession, my lord, বই তো বের করলাম তো kindly, my lord, see, my lord, 166 even my lord, learned tribunal discuss. My lord, 166, my lord, this is a case under, এটা একটু দাও না কি বই মোটর ভেহিকেল একটা দিয়েছি
Yes, I have one.
Kindly see, my lord, 166, who are the claimants. An application, my lord, may I permitted 166. An application for compensation arising out of accident of the nature specified in subsection section 165 by the person who sustained injury by the owner of the property where the death has resulted from the accident by all or any of the legal representatives, not legal heirs, and by any agent duly authorized by the person, provided that where all the legal representatives of the deceased have not joined in my such application for compensation of this application shall be made on behalf of the. So, my lord, the father, being a, my lord, the legal representative, my lord, filed this case and, my lord, the learned tribunal granted the compensations, the parental consortium of 40,000. and funeral expenses and my loss of estate granted. That point which my learned friends, my lord, has, my lord, cannot be sustainable. Now, my lord, third point is, my lord,
Now, question is considering the nature of the establishment. Suppose one iron ore shop is one thing, iron shop is one thing, the other is a sweet shop is another thing. Okay. So, what is the observation that he is unable to prove the income?
No.
That is why 5,000.
My lord, your lordship, kindly see the judgment. My observation of the learned tribunal says is my page 18.
Yes.
My lathe machine, your lordship, kindly see the balance. আরেকটা print দেবেন? Sorry. My lord, your lordship, see, lathe machine.
So, this is with regard to skilled worker.
Yes. Semi-skill. My lord, in West Bengal in 2021, minimum wages or monthly wages for a skilled worker, which would do. Minimum wage as category skill. He's a malad, he's a malad lathe machine malad who has a capacity to malad the operate lathe machine. Malad, he must be a skilled worker. Your lordship kindly appreciate. Some malad, the inference may be drawn. That notifications, malad, that was
What is this? Zone B and
Zone A.
Zone B is 9,593.
Yes. That semi-skill.
Zone B.
Zone B. Zone B না আমাকে আরেকটা প্রিন্ট আউট দিলে দেখি দেখি আমাকে জাজমেন্টটা শো কর Malad, I am handing over the compilation of the judgment. Whether the minimum wages, Malad, followed by the Supreme Court, Malad, category, one category, whether the father is entitled to get compensation, that was included in my, and my lord. My lord, kindly take this matter.
Anyway, conclude tomorrow. Today there is a full court reference.
Your lordship concluded.
No, let him reply. Tomorrow I will hear him.
Yes, your lordship. I need to
Tomorrow, because now there is a full court reference, I have to rise.
My lord, your lordship, kindly have a look.
I'm keeping it tomorrow at the top of the list.
রেফারেন্স তো আমাকে দিয়ে দিবে এটা আমাকে কপি দিয়ে দিবে পড়াশোনা করে আসবে
নিয়ে না তুই দে
একটা এইটুকু আমার জন্য ঠিক আছে থাক
এর মধ্যে সব আছে তো
Yes, record and order. Learned advocates for the parties are present. Heard learned advocates. Let this matter appear for final hearing. Tomorrow or day after tomorrow?
Tomorrow.
Not a problem. The lordship has already heard it, that's why.
25/11/2025.
No.
At 12 p.m.
At 12 p.m.
Deeply obliged, your lordship.
And my lord, the compilation of judgment file
Compilation be kept with the record.
Your Lordship, I have also supplied one copy. Let it be on the record. I will place it tomorrow. Again. Tomorrow against one.
এটার মধ্যে ঢুকিয়ে দিন তো এটা এই কাগজটা।
আমার নাম লাগবে না। অ্যাপিলেন্ট আমি। অ্যাপিলেন্টই আমি।
সিম্পল না।
আরে ও এই রায়ের দ্বারা আমাকে কিছু আমি বুঝতে পারছি না।